The Honorable, the Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everybody. Welcome to the historic courthouse here in Morganton, and your Supreme Court certainly appreciates the hospitality of all the folks here in Burke County and in Morganton. In 2004, well, our state constitution provides that we will hold court in Raleigh and such other places as designated by the General Assembly. And in 2004, the historic courthouse in Edenton wanted that designation for us to come to Edenton and hold court, and so the General Assembly saw fit to do that. And then in 2015, I think it was, somewhere in there, Justice Ervin and I went to the General Assembly. Senator Daniel, certainly, I think he sponsored the bill to allow Morganton to be the site where we would come in the West. This setting is certainly appropriate for the Supreme Court, since in the late 1840s through the early 1860s, the Supreme Court would come here and hold court in August. So in some ways, I guess we're just returning home. But again, we appreciate all the hospitality that the folks here provide for us in our visits. You see 6 of us, but we have 7 on the court. Justice Hudson is joining us, but she's having to do so from home. She's going through all the protocols. We hope that she is feeling well, and she may participate just by texting in some questions to Justice Ervin. So if you see him checking his phone, it's not social media. It is checking to see if Justice Hudson is submitting some questions. She will participate in the decision in all the cases that we'll have, but she is viewing it remotely. We are live streaming this for anyone who desires. We look at the bright lining of COVID, and one of those bright linings are our uses of technology. And we live stream now all of our Supreme Court arguments. So here in Morganton and Burke County, you're able to watch the exhilarating arguments that are made before our court. So after you sit through this morning, you're going to be hooked on, man, when can I see the next one? Well, stay tuned. Speaking of COVID, sadly, one of the attorneys in case 6 told us yesterday that there had been a positive COVID test. So for any of you that know anybody who is scheduled to be here tomorrow for the 3rd case, which is our case 6, please let them know there will not be an argument for case 6 tomorrow. It's just part of the world in which we live right now. Is we keep hoping and praying that COVID will be something in the rearview mirror, and just when we think it might be, it pops up in the windshield again. So anyway, all those little announcements being said, our first case this morning is In Re LNH, and we will hear from the appellant.
Good morning, Chief Justice Newby and Associate Justices. May it please the court, my name is Mercedes Chutt. I'm arguing on behalf of the appellant petitioner, the Guilford County Department of Health and Human Services. My colleague, Mr. Matthew Winchie, is arguing on behalf of the guardian ad litem. We will be sharing our time. We hope to have 12 minutes each and 6 minutes for rebuttal. It is our plan that I will argue about the ineffective assistance of counsel issue and the evidentiary issues, and that Mr. Winchie will argue about the issue pertaining to whether in deciding dependency, the court can consider post-petition evidence. So starting with the ineffective assistance of counsel issue, this case has significant implications for ineffective assistance of counsel because it is the department's position that it sets the bar so low for ineffective assistance of counsel or IAC claims. In this case, the mother's counsel did not object to evidence that had been admitted in a prior proceeding. The evidence at issue was the medical records pertaining to the injuries of the child. The facts of this case are that the minor child, who was 10 weeks old, sustained burns to her feet and had swelling in the abdominal area. The biggest injury was the burns to the feet. The medical records established the child did receive burns to the feet, as well as swelling in her abdomen, and that she was hospitalized for 2 days.
Ms. Chuck, just to ask you a question about the content of the record, many of these issues involve references to the medical records. There are some medical records in the printed record. Are those the medical records that we're supposed to consider in evaluating issues in which the medical records are relevant?
Yes, Your Honor. So the medical records in this at issue were contained in a reasonable efforts report, and those are on pages 20 to 33 of the record.
So when you and Mr. Lunch and Mr. Miller talk about the medical records, those pages are the records that we need to look at?
Yes, Your Honor.
Okay.
Yes.
There's not a separate exhibit or anything like that?
No, Your Honor. So what had happened was...
Before you go too far, can you explain how the report would have been used? Was it just presented to the court, or was it, how did it become part of the record, I guess is what I'm asking you about.
Right. And so we don't really know the answer to that question because the hearing, it was a 7-day hearing, which is a hearing on the need for continued non-secure custody, which by statute has to occur if the parent does not waive those hearings. And one of the things that the court can look at in a 7-day hearing is whether there is a reasonable basis to believe that abuse and neglect and so forth occurred. We don't know what happened at that hearing because there's no transcript and nothing in the record shows what was happened at the hearing. There's no narration of evidence or anything. All we know is that following that hearing, the court entered an order, which is in the record on page 35, in which the court found that the reasonable efforts report was admitted into evidence, and it incorporated the reasonable efforts report into evidence. And so in terms of was an objection made at that time, did the mother consent to it? I think there's an allegation, or it was in Mr. Miller's brief, the mother consented to the records coming in. It's not in the record. Nothing. The only thing in the record that gives any evidence to what happened is that order. It's on page 35 of the record, where the court found that the medical records were admitted into evidence and incorporated them by reference.
Aside from the attorney's failure to object to those records coming into evidence, in all other respects, was the attorney vibrant and active in terms of representing the mother's interests?
He absolutely was. And one thing, so the attorney made several objections. He cross-examined witnesses. He made a closing argument. And I think one thing that's really important to note is I think the Court of Appeals assumed that the trial judge relied on hearsay in the medical records in making its findings of fact. The medical records contain hearsay about reports from neighbors or observers about how the child was injured.
Would this court be setting a relatively low bar for ineffective assistance of counsel if, on one hand, counsel was in all other respects being very active in terms of representing a party's interest, but yet on the other hand, but for one perhaps strategic or perhaps otherwise omission in representation, that we would be holding such to be ineffective assistance of counsel?
My concern is that the low bar requires counsel to object after the judge has already ruled. The record is very clear that all the attorneys believed that the judge had already ruled on the issue of the admissibility of the medical records. Note that this was the same judge that was hearing the adjudicatory hearing that presided over that 7-day hearing where the medical records came in. And there was an agreement among counsel that the judge had already ruled. And I think it's problematic to establish a standard for ineffective assistance of counsel that requires counsel to continue to object after the judge has already ruled.
Is it your position then that it is not so much the quantity of errors or omissions that a counsel may make, but the aspect of how pivotal it is in terms of even one singular omission?
Well, I mean, I'm sure one singular omission could establish ineffective assistance of counsel in some cases. My argument for this case is there was no error. What the record doesn't reflect that there was any error. And with ineffective assistance of counsel cases, the cold record needs to reflect that there was an error.
Is your argument to this point then that everything that's admitted into evidence at a non-secure custody hearing then is already admitted and can be considered at a subsequent adjudication hearing?
I think when you're talking about a narrow evidentiary issue as to whether or not records were admitted,
Well, if that wasn't clear, let me try again. Then. The medical records in question were attached to something that was admitted into evidence. We don't know under what circumstances at a hearing held for the purpose of determining whether non-secure custody should be continued, right?
Correct.
Is it your contention that anything admitted at that hearing is then deemed admissible at a subsequent adjudication hearing?
Not necessarily, no. But I do.
How do we know what is and what isn't then?
Because in this case, the judge made a finding of fact that it was admitted.
But assuming that it was admitted at the non-secure custody hearing, whatever the piece of evidence is that evidence then, because of the fact that it was admitted at a non-secure custody hearing, admissible in an adjudication hearing?
In this case, I think the answer is yes, because everyone agreed about the admissibility.
Why would there be a different rule depending upon what kind of evidence we're talking about, which is where I think you seem to be headed?
I mean, it's just a gray area. So this court has held that courts can take judicial notice of findings of fact in proceedings that do not require the rules of evidence and have a lower evidentiary standard. And I think what is supposed to be the safeguard here in terms of what's probative evidence and what isn't is a trial court. Because the trial judge sitting without a jury is presumed to disregard incompetent evidence. So I don't think there's anything in this record that would establish the judge did not disregard the hearsay reports as to how the injuries occur.
If that information was disregarded, then where is the evidentiary support for the findings concerning the holding of the lighter or whatever it was to the child's foot, to the leaving the child on the porch, to the neighbors intervening? If the support for those findings isn't from the testimony of the social worker, which was expressly admitted for purposes other than hearsay, or from portions of the medical records, where does the support for those findings come?
Okay, so to answer your question, the court did make findings about the report. And the findings about the report are necessary to show that the department had jurisdiction to investigate this family.
And I don't think anybody questions that, but I mean, there also, isn't it important whether those things actually happened as a matter of fact?
It actually is not.
Okay.
To answer your question. So the reason why is because it isn't necessary to establish causation to show either neglect or abuse. So for abuse, one only needs to show that a child received injuries that were not accidental in the care of the parent. It isn't necessary for the court to determine how the injuries occurred. With neglect, it's only necessary to show that the child was in an injurious environment. And as we all know, that the fault of the parent is not an element in either abuse or neglect. If you read the order carefully, I would submit that the trial court did not find that the mother had done all the things that the so-called neighbors reported. So the trial court didn't find the mother had, swiped the lighter over the child's feet, sprayed some green liquid on the child, beat the child in the stomach. The trial court did not find that. That was the so-called neighbors report. The trial court only found that the child was injured. And if you notice, all the findings are their passive voice, was injured. The injury occurred in the mother's care, but not that it happened the way the neighbors reported it to happen.
But wouldn't those findings of the parent's fault and causation be necessary for the trial court's, the part of the order that eliminated reunification and reasonable reunification efforts for the mother and at this initial permanency planning order?
Well, in my opinion, no, because if you look at the catch-all provision under 7B 901CF, the reunification efforts can be ceased by any conduct that enhances the character or the abuse or neglect. And my argument, is there that basically for neglect, for example, it isn't necessary to show the child was actually injured for neglect. It's a risk of injury. And also, it's not necessary for either abuse or neglect to show that the child was seriously injured.
But wouldn't it be necessary to show that the parent was in some way at fault or caused the injuries in order to eliminate reunification as part of the plan?
In my opinion, that's not in the statute. If you look at the catch-all provision, it only states that there has to be some evidence to enhance the character of the abuse and neglect. Also, the court can consider those reports, the hearsay reports, a disposition.
Then just one other quick question, because I know you're running out of time. Isn't it true at the 7-day hearing that the mother was not represented by counsel? She did not have counsel yet.
I do not know that.
Because wasn't there an order appointing her counsel at that same hearing?
There may have been, and I don't know the answer to. I'd have to look at the record. That could be the case.
Thank you.
So my point with IAC, ineffective assistive counsel, is simply that, here you have to, I would argue there wasn't a mistake made by this attorney. I don't think it's a mistake to agree among counsel that something has already been admitted into evidence. And I don't think that the standard should be such that counsel is required to continue to object, ask a judge to reconsider their ruling when it's already been made. And I would argue there's nothing in the record to suggest.
But Ms. Chutt, don't our appellate procedure rules provide in essence that if evidence is admitted without objection, even though it might have been objected to at some other time, the objection's waived?
You're saying that the parent,
I
I think so. I think that the objection would have been waived. And I think that's another problem, that I think this is just a real stretch here to say that this attorney did anything wrong. Particularly when, if you look at the transcript too, even in his closing arguments, page 25 of the transcript, he makes the argument again that the judge should not consider the hearsay reports about the neighbors, what the neighbors saw in the court's adjudication. And he objected when that came in terms of having it being used for the truth of the matter asserted. So I think it's a case where it's hard to find what the attorney did wrong at all. Okay, and my time is up. Thank you.
Thank you, counsel.
Mr. Chief Justice, and may it please the court, my name is Matt Wunsch. I'm appellate counsel for the Guardian Ad Litem program, and I represent the juvenile Leah before you today. I'm going to focus on the dependency issue, but I did want to respond in one way to Justice Earle's question about the ceasing and the evidentiary issue with the ceasing part of the order. I don't want to step on Ms. Schutt's issue here, but I did just want to mention that causational finding, I think that Your Honor could, the findings to support ceasing are dispositional findings. And so they don't need to be made according to the rules of evidence. It's whatever the trial court finds to be relevant and reliable evidence. Hearsay is expressly allowed in disposition. So even if there was a hearsay issue with that evidence required to make the finding of fact that Your Honor was talking about, it wouldn't matter for a dispositional finding. But the issue that I want to focus on before you today is the dependency and the post-petition evidence issue. Your Honors, if we have a system where different rules apply at different cases, we can't do justice for all children and families. And that's what we have right now. We have an ad hoc rule for what evidence is admissible to support adjudications of abuse, neglect, and dependency, particularly dependency, as the case law has evolved. So there are three main points that I want to focus on as I talk with you about this issue today. The first is that the plain language of the juvenile code is clear that the critical moment for an adjudication is, or the critical determination is the existence or non-existence of the allegations in a petition. Second, that limiting adjudications to that particular moment in time provides clarity for all the parties involved, for parents, for children, for DSS, frankly, who has the burden of proving those allegations. And that certainty is good in any context, but particularly in this context where the issues are so important. So there should not be an exception for post-petition evidence to come in at adjudication. And then finally, as an alternative, if the court wants to continue to extend this post-petition evidence exception, that it should truly be narrow in scope, that it should truly be for immutable conditions, for things that are truly fixed and ongoing, not ad hoc to be decided on a case-by-case basis. Turning to the first point, Your Honors, the plain language of 7B802, which is the determinative statute here, says that the existence or non-existence of any of the allegations alleged in the petition is the determination the trial court has to make at adjudication. That's the plain language of the statute. It's unambiguous. The analogy that I think of is to an indictment in a criminal case. Now, it's not the same determination because we're not proving fault. It's about the status of the child, not the fault of the parents. That's another very important consideration here. But there is an allegation that has to be proven or not. And there's a particular time at which that happens. I look back at the history of the statute, and that has been the same since it was enacted more than 20 years ago. That moment is the one that was fixed as the moment that matters. And the initial case law from the Court of Appeals was very clear, in Re AB, in Re JR, where parents had asked for the court to make an exception to that rule. No, that the plain language of the statute is unambiguous. That's the point in time that the General Assembly has set. And so that's what is going to have to be evaluated. What were the conditions at the time the petition was filed? Post-petition evidence, those cases.
Let's talk about the language of the statute a second. It says adjudicate the existence or non-existence of any of the conditions alleged in the petition. I mean, I could probably, if I put my mind to it, interpret that 2 or 3 different ways if I thought about it a little bit. The issue is you have to find the condition, which would be either abuse, neglect, or dependency. As of, it doesn't say as of the time of the petition, it says alleged in the petition, the condition alleged in the petition. Why should we read that language the way that to be plain and unambiguous in the sense that you have argued in your brief and argued here again this morning?
Well, Your Honor, I think the language is plain in that it's saying that the existence or non-existence of any of the conditions alleged in the petition That fixes the point in time at which the trial court is supposed to evaluate the evidence. So evidence of things that happened after the petition necessarily were not conditions that were alleged in the petition. And those conditions could change in either direction. You know, we have a relatively short window of 60 days from when a petition is filed to when an adjudication hearing is supposed to happen. And you see in the case law, it going to the benefit of one party or the other in different cases. Conditions could improve, conditions could worsen, post-petition evidence. And maybe I need to clarify too what I mean by post-petition evidence. I've just been using that term without really explaining what I mean by that. I don't mean evidence that came to light later of conditions as they were at the time of the petition. I mean evidence of conditions after the petition was filed. So circumstances
Well, okay,
and I apologize if that was not
Let
clear.
me make sure I understand what you're saying. Then, in this issue, in this case, the real issue appears to be whether there was an adequate alternative arrangement for the care of the child. We've got some folks, and I understand your argument that mother didn't present some of these people, but putting that aside, let's say hypothetically, the mother had suggested these other folks that came to DSS and offered to assume responsibility for caring for the child. If, as a matter of fact, at the time of the hearing, these folks were an adequate child care alternative, would that preclude a finding of dependency?
No, I don't believe so, Your Honor. And that is
why not? Because I think I understood you to concede that if the fact existed at the time of the petition, then you could consider it, even though it might involve other information over a broader period of time. Why would?
Oh, well, I'm sorry, I apologize. If I said it that way, I misspoke, Your Honor.
That's the way I understood it.
Okay,
And that's
I
the reason I asked you
apologize.
about it was because I did not think that was consistent with what I'd understood your argument to be.
No, I mean evidence of conditions that evolve that could not have been known at the time of the petition. So that's the condition, that's the circumstances we have here.
But so you're saying that in the event that these folks were in actuality, as of the date of the petition, capable of providing care for the child, that evidence doesn't have any bearing upon whether the juvenile was dependent?
Not if it comes to light post-petition. Correct, Your Honor. That's a
So if you
dispositional
find out
issue.
about it, so your argument is, even though it may have been a fact as of the time of the petition, if that wasn't known to somebody, I don't know who we're talking about exactly, DSS, the court, whatever, that fact doesn't have any bearing upon whether the child was dependent.
That's right, Your Honor, because it's not an allegation in the petition. The allegations in the petition are that there's no caretaker, the parents are incapable and there's no alternative caretaker available. And so the DSS agency who has the burden at that point is responsible for showing or not showing, trial court's responsible for finding or not finding those conditions as alleged in the petition. The post-petition evidence, and this case is a good example of that, in that you have the relatives who offer themselves forward, but you can see in the record, the evaluations don't come in until after the fact, after the petition is filed.
Well, is the important thing what DSS thinks about them, or what in fact was their set of circumstances?
Well, I think it's what's known at that time, Your Honor. So it's not really a question of what they think about them.
Known to whom?
Well, known to the trial court, most importantly.
Well, the trial court's only going to hear it sometime later. It's not
Right.
going to hear it at the time of the petition. So I'm having trouble seeing why the trial court's knowledge would be determinative of what was a condition, what was true as of the time of the petition.
Well, because there was no party that knew it at that time. I mean, in this case, Your Honor, in particular, we have the relatives who come forward. They aren't offered by the mother as a potential placement. Only after the fact is it determined that they are, and one of them is a good placement for the child. Ultimately, as it should be, that's a dispositional issue, and it's a good result, I think, for everyone involved, is that the child is placed with a relative. It's a dispositional decision that is made if that placement is appropriate, and it turned out to be in this case. The problem we have is conditions change. Child care placement options change over time. Again, we're talking about a relatively short window between the time a petition is filed and the time an adjudication should be heard, but things can change back and forth in that time. A relative could move, their home could change. As we had in this case, you have another family member living in the home who needed to leave before it became an appropriate home to place this child. So that's something I think, even evaluating the evidence we had about that placement, it was not appropriate at the time the petition was filed. That had to happen before it could be approved and before it became a placement option for the child here. So even in that window, it doesn't really work. But what we have now is cases going up to the Court of Appeals and different panels deciding, okay, what is a fixed and ongoing circumstance, and reaching different results. We have paternity, which to me sort of stands out as the one fixed and ongoing circumstance that isn't going to change once it's established. We have one panel saying substance misuse. Well, the parent has addressed her substance misuse since the petition was filed, and so now that's a fixed and ongoing circumstance. We have another panel talking about housing, unstable housing. Well, that's been resolved. Now that's a fixed and ongoing circumstance. I think anybody that works in this area of law knows that those are extremely, extremely changeable circumstances. They are not fixed and ongoing. They are what our cases are about, that parents have a substance misuse problem and relapse and get back on track and relapse. And unfortunately, it's a sad story, but it's the kind that we see over and over again. So I urge the court, if the court is inclined to keep the exception, I think the bright line, clearest answer is to go back to the AB standard, to the statutory standard that I argued for, to make it the evidence at the time the petition was filed. What were the conditions at the time the petition was filed? But if the court is going to keep the exception, to truly narrow it, and I've thought about this a lot, I cannot think of another condition that is analogous to paternity in this way, that is truly fixed and ongoing, that is not going to change over time. It's just not the nature of our cases. And I apologize, I see that I've eaten into our rebuttal time. So if the court has no further questions, I will just ask you to reverse the Court of Appeals.
Thank you, counsel.
Thank you.
We'll hear from the Appellate.
Mr. Chief Justice, Associate Justices, I'm Jeff Miller from Greenville, North Carolina. It's an honor to be here today representing the respondent mother, Loretta Ford, and the correctness of the Court of Appeals decision in this case. To get right to the heart of the matter, it is my position that there is not a high bar or a low bar for effective assistance of counsel. There is a bar that we hold licensed attorneys to that's reasonable, that has objective standards of practice. And when there's a failure, we recognize it as a deficiency. It is not a criticism necessarily of the person. It is a bar in the practice that's an important one. And in this case, the lawyer failed to object to the only evidence that supported the trial court's decision and adjudication, the hearsay evidence with regard to the mother's conduct and behaviors, and the ultimate status of the child. I would point out one thing that I think is important as we look at this, and I know that we speak a lot about the status of the child and nobody being at fault, but if you read the definitions of an abused juvenile, it requires that the parent inflict or allow to be inflicted the harm to the child. So it does require conduct on the part of the parent. Similarly, in injurious environment cases, you might have an innocent parent and a parent who keeps a child in an injurious environment. Just because there's an innocent parent who's not at fault, that child's status can still be a neglected juvenile. In this case, the only evidence that came before the trial court that supported its order was evidence that was not admissible because it was hearsay evidence. It was not competent, it was not clear and convincing evidence, and it was not evidence that our statutes say we must rely upon when we adjudicate in these constitutionally important cases that involve fundamental family relationships.
Didn't the trial court say that the evidence was being admitted by the trial court, not for the substance of it, but merely to respect what DSS was saying, which was this was the way in which DSS came to be involved in the first, or DHHS came to be involved in the first place?
Justice Morgan, there are two instances with regard to the identical evidence. And the first instance had to do with the report itself. And when that testimony was proffered as the reason why DHHS became involved, this trial counsel objected to that evidence as hearsay, and it was acknowledged by DHHS and by the court that it was not being admitted for its truth. So that objection prevailed. To some extent, though, the court's order seemed to, and I think the Court of Appeals felt, seemed to use that evidence in its decision. The second occasion, though, is where the lawyer's failure comes into play. And this is critical because the evidence that was involved came into play at a non-secure custody hearing where hearsay evidence is admissible and is appropriate for that temporary and that limited decision protocol. And we know in this case, the court's finding says that it was accepted into the record as part of today's evidence, a previous exhibit admitted in May 10, 2010. Doesn't say how it was admitted, doesn't say anything about there was a subpoena or that there was a witness or anything of that nature, but it was admitted by judicial notice, not through any authentication or offer. And the record is clear what happened. And I have indicated that it is a bit galling to say we don't know what happened. We do know. The record shows that a reasonable efforts report to which this limited medical record was attached was submitted on May the 10th when Loretta did not have a lawyer. Her lawyer, the record shows, was appointed May the 10th. And Loretta, at that time, consented to the non-secure custody order because she just got served with a petition that day. She just got a lawyer that day, and nothing had really been decided in the case.
But as to ineffective assistance of counsel, wouldn't we as a court be perhaps dangerously lowering the standard for ineffective assistance of counsel if counsel was in all other respects, even including the first opportunity to enter an objection which was sustained, to be able to say nonetheless that the counsel was somehow deficient?
I think that the case law, at least the Court of Appeals case law, is very clear that when hearsay evidence is the only evidence that supports an adjudication, that it is prejudicial error to not object to that and to allow that evidence to come before the court. We're not lowering the bar. And as a lawyer who practices in the court, we ought to maintain a high bar for practice. We ought not to be saying to DHHS, to the courts, or to lawyers practicing in our juvenile courts where children are being taken away daily, adopted out, where families are disrupted for periods of time. We ought not to be saying to them, well, we've got a low bar if you don't object to the only evidence that will establish the adjudication of a child as abused or neglected. And in this case,
Mr. Miller, let me to follow up on the question that you were just asked. I had generally understood that we looked at allegations of ineffective assistance of counsel on an issue by issue basis rather than trying to evaluate whether the lawyer's overall performance was adequate. Do you?
Your Honor, I honestly, I've been involved in a lot of cases where ineffective assistance is alleged and where sometimes the Court of Appeals or this court on occasions notices it. And it is indeed, I think, on a case-by-case basis. And where we get into the questionable area is if we can discern any strategic or litigation purpose in what the lawyer has done rather than some on its face deficiency.
Well, and I guess that was going to be my next question. I think this court has held in a criminal case is the question of whether an attorney acted on the basis of a strategic or tactical decision was a question of fact, so that we shouldn't hypothesize whether there was actually a decision made, but it required a factual finding as to whether that was the case or not.
And in looking at this case, there is no way for this court or anyone to even say that there's a factual issue here about a strategy or a litigation purpose.
Well, I mean, let me posit you a situation and see what you think about it. The information to which you object is contained in a number of places in the record. You've already talked about the testimony of the social worker. There's also a summary of these statements in the medical records. Admittedly, you have hearsay upon hearsay issues with respect to the medical records, but would it be a tactical decision to say, in effect, if they really want to take the time to bring in the custodian for these medical records, they could get them authenticated anyway? I'm going to look bad if I waste the court's time making them prove something that they can prove pretty easily if they just bring somebody else here. Therefore, in order to avoid irritating the court, I'm not going to make them do that. Would that be an unreasonable decision in your view, assuming that that was the decision that was made?
Your Honor, if you're asking me, I'm going to say very clearly and without hesitation, it's an unreasonable choice to say I'm not going to put DHHS to the test that the statute requires in order to adjudicate abuse and neglect, and in effect, as happened in this case, terminate a parent's entire rights.
Of course, at the time that the counsel did or didn't object, it would have been a little hard for the counsel to know that you'd get the subsequent finding of a lack of no necessity for reunification.
In this case, Judge, I don't believe that there was any question about what the posture was going into the trial, but the record is not clear on that. I will have to concede that.
Because in looking at it, it appears to me to be something that came up during the course of the hearing. I didn't see anything. I may be wrong, and please point me to it if I am. I didn't see anything earlier on that asked for a cessation of efforts of reunification at this hearing before the hearing.
There was not notice of cessation of reunification given in writing in any sense in the case. Counsel did, in a statement of the court, ask that the permanency planning about the reunification be continued and not be held at that time. But what I want to say, Judge, is, Justice Irvin, is this issue is not a low bar issue. It is a hearsay issue. It is a fundamental evidence issue, a matter of law that is clear. There is no excuse for saying, I'm not going to put somebody to the test. The truth is that record, we don't even know who's saying things. We don't know where these statements came from, how many neighbors are involved, how many observers are involved, who's saying what to who. We don't know any of that.
So in your view then, and I've got one more question beyond this one, but this is one that Justice Hudson wanted to ask. We're going to try this technique for a while. What, in your opinion, should the lawyer have done specifically at the hearing?
In terms of the request at the trial, should have objected to the judicial notice of a non-secure custody order document that was introduced with hearsay in it, because, and there is a Court of Appeals decision, the JMCJM case, that explains the dangers and the problems with allowing a court to take judicial notice of non-secure custody hearsay type hearings, hearsay information in making adjudication decisions. They recognized that problem. And it is fundamental that if that is the only evidence that the lawyer has acted deficiently, that there is no question of prejudice, and that there's a reasonable probability, had that evidence not come in, a different result would have occurred with the adjudication of abuse and neglect.
Let's say, I mean, the Court of Appeals held, among other things, in its opinion, if I'm reading it incorrectly, tell me, but this is the way I read it. In essence, this evidence shouldn't have been admitted. Therefore, the findings lack sufficient evidentiary support. Therefore, the adjudication is reversed. Is that a fair reading of their order?
The adjudication of abuse and neglect was reversed. The dependency was a different.
Right. Typically speaking, when you have an evidentiary issue, the remedy is a new hearing, not reversal for insufficiency of the evidence, isn't it?
As I read the opinion, it reversed and remanded, contemplating that there would be some type of new hearing.
Okay.
It reversed completely the dependency adjudication. So I do think that it's absolutely important and critical that we recognize this was the only evidence that supported this entire order for the adjudication of abuse or neglect.
Mr. Miller,
Yes.
if I might interrupt, I'd like to take you back to your discussion about what abuse is and what neglect is,
Yes, ma'am.
and particularly neglect. The way, and again, setting aside your legal arguments about hearsay, the way I read the facts of this case is they were found in the order that this the mother took 2 shots of vodka, went to sleep, put her baby to bed, went to sleep, and woke up with her baby severely injured in the hospital. How do you reconcile that to not be neglect when a mother goes to bed having had consumed alcohol and inexplicably her baby is carried off to the hospital?
There's a lot we don't know about what occurred at that time, but we do know that the law says injury alone is not sufficient to support a neglect adjudication. We do know that. We do know that taking a double shot of vodka is not neglect by a parent under any stretch of the law and the determination. All we know, we don't even know who else lived at this residence. All we know is that this mother put her baby to sleep, took a double shot of vodka, and went to sleep herself, like so many others do. How it transpired from that point on, we don't know. There's not evidence in the record that allows this court to simply jump to an adjudication of neglect under the statute that makes the case basically on facts from which a court could make findings. That does not alone constitute that neglect.
I think Justice Hudson would like to ask, is there any evidence from which one could find that anyone else was the perpetrator of these injuries?
Of course, the burden is upon the department. The evidence was sparse in this case on adjudication. I think it was about 16 pages of a transcript. And like so many of these cases, there are just assumptions made and practices conducted very quickly without really figuring out what occurred. You know, this mother was never given an opportunity to explore with anybody what occurred. She didn't remember. She was very candid about that. I want to also remind the court, this is a young mother who had no prior history with the department, who had no criminal record, whose family said she was a good mother to her child, always acted appropriately with her child, who, when she was arrested, while she's in jail within the course of just a few months, completes parenting classes, anger management classes, is asking to have a therapist, who is doing all things right. So we ought to have a lot of questions about what occurred here, what did occur. And the evidence just is not there sufficiently, clearly, convincingly, competently.
Well, there's no dispute that this child's feet were severely burned.
Judge, there was a partial thickness burn, and I will say that is a serious injury. I will not try and argue about that issue at all. It's akin to, if you read the literature, sunburn, scalding with hot water kind of burns.
Well, it also got infected, at least in the left foot, which caused some follow-up visits, that type of thing. And there's also no dispute that the mother was arrested for these injuries. Isn't that correct?
There is no question she was arrested. She was in jail when she was talked to by the agent.
And certainly we expect the role of DHHS to protect. In this case, the child was about not even 2 months old.
That's
when
correct.
This child was burned.
That's correct. Those facts are indisputable. There's not any question about that. The question is what is the evidence that supports an adjudication under our juvenile law? And we have a standard for that. We have a rule of law. We are consistent that we defend the Constitution and the rule of law.
When a 1.5, 2-month-old child has severe burns on her feet, certainly that her status, the status of the child, is having been neglected.
The case law is clear that an injury alone is not sufficient to adjudicate neglect. I think there are numerous cases to that effect. It requires more. And that's what I'm here about is it does require more. And the problem in this case is not only was this mother treated so severely in terms of the error that allowed the adjudication of neglect and abuse to occur, but in terms of the kind of mother she was and allowed no opportunity. She, in effect, had her parental rights terminated. She wasn't given an opportunity for WebEx visits with her child or for supervised visits with a sheriff or a family center or in any type of relationship at all.
There's no dispute that medical records are routinely admitted into evidence in courts across the state with regard to hearsay exception. Isn't that true?
It is true in a limited sense, Judge. There is case law, and I've cited it, State v. Smith, that hearsay statements within those medical records can still be subject to objection.
But we also know that one of the reasons that medical records are admitted is that there's a common sense understanding that people give accurate statements to the medical providers for medical care.
Chief Justice Newby, that's correct, but it requires further explanation. That rule, the medical treatment exception, is based upon the patient coming to a doctor and saying, here's what happened, here's what's wrong with me, and that they're motivated to tell the truth about that.
How did this 1.5-year-old child get to a medical provider? Did the mother take her?
Judge, I was going to go on. We do have an exception also that says parents of children can provide that information for these young children. Here, we don't even have a name. What we have are neighbors or observers, and we don't know how many of those.
Where was the mother?
The mother was in her home, asleep.
Well, I think there's some testimony or evidence or statements that she ran away.
The mother ran away?
Yes. I mean, if you look at what the neighbors said, they said she got a lighter out, that she sprayed the child with some kind of green liquid, that she hit her in the stomach. And then when the neighbors came over, the neighbors said she ran away.
The actual testimony is, and it's recited in my brief, says that the neighbors took the child from the mother and she went in the house. And again, we don't know what happened with this mother. A single isolated incident she doesn't remember and can't tell us. No one took the opportunity to even explore that. And I think that that's critical to remember in this case, Your Honor.
The record contains two different descriptions of statements that your client made to DSS workers. One, the same witness testified to both of them. They were pretty similar. That evidence is admissible for the truth of the matter asserted. It.
As I indicated in my brief, there's no objection to that evidence. And
even if there had been, we can quibble about whether it's an admission in the lay sense of the term, but typically a party's statements concerning past events are admissible.
That's absolutely correct. Yes,
And
sir.
so the trial court, regardless of whether anything else was subject to being admitted, could consider that testimony.
And that testimony was,
Well, that testimony was, as I recall it, and correct me if I'm wrong, because it always helps me to make sure I'm understanding it correctly, is that the child was with the mother. They were in the home. The mother drank vodka, went to sleep, and the next thing she knew, the child wasn't there.
we don't know how much time elapsed through all of that, but it was, she put her child to sleep. She took a double shot of vodka and she went to sleep herself, and she doesn't remember anything else. And her mother woke her up and said, the child's at the hospital. Why is the child at the hospital? And she didn't remember any of that. That evidence doesn't establish anything for purposes of an adjudication. We can certainly say it's not the prettiest picture for a parent, but it doesn't establish under the law, under the rule of law, the neglect or abuse.
Is it your contention then that you could not find the existence of neglect on the basis of a parent having consumed alcohol to some degree and then not being aware that the child was being removed from the house until the child had been taken to the hospital?
It is so difficult to say that a parent who puts their child to sleep, has a drink, goes to sleep themselves, must be aware of all of those kinds of facts. Even in Stumbo, decided by this court, the court recognized that every deficiency of a parent does not automatically rise to the level of neglect. I do want to address.
And before you do that, Justice Hudson had one other question I wanted to get in. And it's just a question of what does the record reflect? There was some discussion with your colleagues about whether the evidence the records had been admitted at the non-secure custody hearing before or after the appointment of counsel. Can you shed any light on that question?
Your Honor, I can only suggest that all of that occurred on the same date when the mother is served with process, her counsel is appointed, and the non-secure custody order is entered with the reasonable efforts report at that hearing.
So at least as you understand it, the record is not clear as to whether the mother had counsel at the time that hearing was held.
Counsel was appointed at that point. Now, what transpired in terms of the chronology of those events? Generally, these initial non-secure custody orders that are entered without counsel. Most of them don't involve counsel at all, the initial one. I want to speak to a couple of other matters important. The dependency adjudication. And I think the Court of Appeals has asked guidance of this court. Both Judge Dietz and Judge Inman asked that the legislature of this court give some guidance in the principle. And I want to suggest to the court that dependency is substantially different than neglect or abuse. When we talk about conditions that are alleged in a petition, dependency is a condition where there's a child who has no parent and no one else as an alternative caregiver to take care of them. Why would we adjudicate a child as a dependent if they've got somebody who can care for them at any point up to the point of adjudication? What is the purpose of that adjudication? Whereas with neglect, we're saying here are the conditions that existed that caused us to file this petition. And we filed this petition based on these conditions, not on, and if the cases AW and JR were neglect cases, we're not talking about that neglect, that condition that existed that caused the petition to be filed. In this case, this court and department had sufficient opportunity for non-secure custody order under the neglect and abuse allegations without regard to the dependency. They simply did not take the time to even investigate that issue. And they say that very clearly. We just didn't have time to do that. We don't know. I couldn't tell you whether they were good or they were bad. That's in the record. In fact, the Goodman home was approved in the record on May the 15th by signature of a department's agent.
What importance, if any, should we ascribe to the fact that the trial court said it didn't have time, in its estimation, to allow a home study to be conducted and didn't authorize DHHS to do that because of the exigency of the circumstance?
I don't have a bit of problem with that, but they can control that with the abuse and neglect. And in fact, by May the 15th, they knew that there was an alternative caregiver for the family, for this child. I also want to suggest that the mother did, in fact, propose prior to the filing of the petition, and that there was an alternative caregiver prior to the filing of the petition. And at the time of the filing of the petition, Cyrita Brown, the godmother, was proposed. And this family, when we look at the rule, I guess, that says, well, the mother or the parent has got to suggest the caregiver. Really what we're saying is we're not going to allow an alternative caregiver to be part of the plan that the Department of Social Services or DHHS has. We're going to require some input by the family. This family showed up for this mother. And if you look at the orders, you will see family appearing in court with this mother. You will see family going to the department wanting to take care of the child. And they did that prior to the filing of the petition. So the dependency here did not exist. Dependency is a situation that was not necessary for this child. The evidence indicated it wasn't necessary. And what was the purpose of it? Why do we have the dependency? So it is an ongoing type of situation. If at the adjudication, the child's not dependent, why adjudicate that child dependent? There's no purpose to it. It doesn't fit anything in the statute for why we have dependency as an adjudication. I've not had an opportunity to talk about the reunification issue. That is critical in this case. This is a mother who deserved an opportunity. She deserved that opportunity to be around her child, but she deserved an opportunity to show that she was not the person that everybody thought May 7th represented or May 8th represented. She was that person who could be a good mother, who was a good mother, who, given the opportunity, she showed her participation, her efforts. She showed she was deserving of that opportunity. There was no finding of a lack of success by this mother. She went above and beyond under the circumstances she had. I ask you to affirm the Court of Appeals.
Thank you, counsel. Rebuttal.
Yes, Your Honor, I'm going to try to limit this to 1 minute if that's possible. So my co-counsel can have his minute as well. So first of all, the order on page 35, the order of May the 10th, does state that Attorney Jaron Dickerson was present for the mother. So I assume from that order, it appears that that attorney was present and representing the mother. It's not correct that the only evidence that supports the adjudications of abuse and neglect was the medical evidence. The mother's statements, which are admissions of a party opponent, do show that the mother had custody of the child on the night in question. The mother did drink the double shot of vodka, went to sleep, and when she woke up, the child was severely burned. So all we need to show for abuse and neglect is the mother had custody and control of the child, and the child was severely injured. The only thing in the medical records necessary to prove neglect and abuse is the actual diagnosis. The stuff about the neighbor statements is just irrelevant, and there's no indication that the court relied on that.
I understand. I know you only have a minute, but I understand the position that hearsay evidence is relevant on the question of whether the trial court erred in eliminating reunification. But what's your response to the argument that the trial court's findings don't meet what's required under 7B 901C to eliminate reunification at this stage?
Well, the response is just basically, again, what I wrote in the brief, that if you look at the catch-all provision, it does say anything that can enhance abuse and neglect. And I think what we have here is severe injuries to an infant and the mother not even knowing how they happened. And I think that's another, issue. Whether she was not being truthful or whether she blacked out, I think both are very, either option there, I think is very concerning when we're talking about reunification efforts with a small child.
And I see your time is up, but I do want a clarification. I heard the counselor on the other side speak to this, the burns like a sunburn. My understanding is third-degree burns actually burn away the skin. Can you comment on that in your last 3 seconds?
The only thing I know is this partial thickness burns. That was what was in the medical records. So I didn't see anything that said second degree, third degree. Frankly, if they did, I don't know if that would mean that much to non-medical professionals such as myself. But we do know that there was a healing process that took several weeks, and then the wounds had to be cleaned and debrided, especially in the left foot, and that there was a foul odor coming from the feet, especially the left foot, and this didn't resolve itself for a period of weeks.
Thank you, counsel. Thank you to everybody.
Thank you.
Mr. Miller, we particularly appreciate you coming up from Greenville. Hope you've enjoyed the mountain view.
Thank you very much, Judge.
Mr. Clerk.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 11 a.m. God save the state and this honorable court. Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everybody. It's wonderful to look out the windows and get to see the beautiful mountains around us. We don't have that in Raleigh. Hence, the Supreme Court is grateful for the opportunity we have to return to an area where we used to hold court. Court in the 1840s, late 1840s to 1860s, early 1860s would come to Morganton to hold court. And our state constitution provides that we hold court in Raleigh or such other places the General Assembly may designate. So the General Assembly has designated for us to be able to come to Morganton in the west and Edenton in the east, and it's such a treat to get to be here. You'll notice that there are only 6 of us. Justice Hudson is participating as she is watching the live stream, but also she will be communicating, texting with Justice Irvin when she has questions that she would like asked. She's going through the protocol. Funny, 3 years ago, nobody, what protocol? Well, we all know what that means now. She seems to have been exposed. And speaking of COVID, sadly, one of the attorneys in our last case tomorrow has tested positive. So if y'all know of anybody who is scheduled to come to see the last case on Tuesday, please tell them come early because there will not be a last case, or there will not be a 6th case tomorrow because of the illness of one of the attorneys. Counsel, we appreciate y'all being here this morning. And the next case we have is State versus Hooper, and we'll hear from the appellant.
Thank you. May it please the court. My name is John Corella, and I represent the appellant, Mr. Ivan Hooper. I've come here from the Office of Appellate Defender in Durham County. Sitting to my right at council table is Appellate Defender Glenn Girding. I'd like to reserve 5 minutes for rebuttal. Ivan Hooper's case comes to this court from a divided opinion in the Court of Appeals. Court of Appeals majority erroneously concluded that the trial court's denial of a requested jury instruction on self-defense was an invited error insulated from all appellate review. I'll begin my argument today by discussing the doctrine of invited error and the Court of Appeals' expansion of that doctrine in this case. Next, I plan to address why Mr. Hooper's request for self-defense instruction was preserved for de novo review. And finally, I'll argue that self-defense was a substantial feature of this case, and the trial court committed a prejudicial error by denying Mr. Hooper's request for an instruction on self-defense. So first to invited error. Prior to the Court of Appeals opinion here, invited error has been a relatively straightforward and long-standing rule in North Carolina. The basic gist of it is you cannot ask the court to do the wrong thing at trial or do the wrong thing yourself and then complain about it on appeal. As it's codified in the statute, the language is, a defendant is not prejudiced by the granting of relief which he has sought or by error resulting from his own conduct. The classic case showing invited error was this court's decision in State v. Pravet, a capital case from 2002. That was a case in which defense counsel asked the court for an instruction on life without the possibility of parole as a possible verdict, and then argued that to the jury. And then on appeal, assigned as error the giving of that instruction because, in fact, at the time the crime had been committed, life without the possibility of parole was not an authorized sentence. And this court found that the error was invited defense counsel had actually requested that instruction and, argued it and the defendant could not then assign it for relief on appeal. Similarly, State v. Barber, a Court of Appeals case from 2001, also cited in the briefs, shows how this can happen during trial. The defense requested that an unredacted exhibit be given to the jury, and then on appeal, complained about that exhibit being given to the jury, although it was clear from the record that defense counsel knew it was not redacted and had made the request that it be submitted. What happened in this case is different. Here we had a 3-day trial. At the end of the second day, all of the evidence had been presented. The trial court held a charge conference as required. Defense counsel did not make a request for self-defense. At the charge conference, there was not a discussion of a self-defense instruction. The following morning, when the parties came back before closing arguments and before the jury was called in, at that point, defense counsel requested the pattern instruction on self-defense. The trial court heard arguments from both of the attorneys and then denied defense counsel's request for the instruction. The Court of Appeals held that because counsel didn't make the request at the charge conference and didn't make an objection, I guess, at the end of the charge conference, and then didn't make a second objection or request after the instructions were then read to the jury, that this was an invited error, that counsel somehow brought about this error. This would be a broad expansion of the doctrine described from cases like Privet and Barber. And it would expand invited error beyond recognition and essentially eliminate plain error review of jury instructions. It's clear from this court's precedents, including the Lawrence and Odom cases, and also State v. Coley from just 2 years ago, which dealt with the self-defense issue, that if defense counsel had done nothing, if there was no objection, the issue could be raised as plain error, would even get some review then. But here, the trial court has somehow transmuted what happened into this case into a supposed invited error that insulates it from all review. This would defeat the purpose of the rules, which are to allow the trial court the opportunity.
So what do you contend is the appropriate scope for the invited error doctrine?
Well, the appropriate scope for the invited error doctrine is that there needs to be an invitation, an action by counsel to bring about the error complained of on appeal.
So it's kind of a you asked for it, you got it kind of rule?
That's right. That's right. And I would say that if you want to discuss where the line is on this in terms of approving something, the case of State versus White, which is discussed in the Court of Appeals opinion, is a case about that, where in White it was again a capital case, and the issue was a peremptory instruction, and the defense counsel didn't submit a proposed instruction or submitted a pattern instruction that didn't have the language he had asked for. And the trial court then proposed an instruction. So in that jury conference, unlike this one, there was a lot of discussion of the instruction at issue on appeal. And the trial court read out the language that the trial court was going to give. And defense counsel said, yes, that's what I want. Approved that language, and then it was given. Well, that was an invited error because that essentially was counsel's request for the language that the court had given. There's nothing akin to that here.
Are you saying then that the passivity of a defendant, conversely, cannot constitute invited error? The passivity here being the lack of voicing an objection at the time that it would have been appropriate, and instead being tardy and doing it the next day.
I believe that's correct. This isn't a situation in which an objection is the issue. Passivity might be something closer to White, might be more possible when if the trial court had read out, a self-defense instruction. But here what we're dealing with is an instruction that was not given. So there's not really a way for there to be, for you to passively,
I was trying to be relevant to what my
Yeah.
colleague Justice Irvin had
Yeah.
raised, that you agreed with his assessment that it was in effect, to be colloquial about it, you asked for it, you got it. Then the reverse would be you don't ask for it, and therefore something's wrong.
yes, I mean, this is, I think what you've described is sort of the plain error scenario where no request is made. The issue just isn't raised before the trial court. And then there's the question of, can you raise such an issue by meeting the high standards of plain error? Because the trial court wasn't informed of it, the parties didn't discuss it, and now you want to raise it on appeal.
Is the Court of Appeals perhaps using the wrong vernacular in calling it invited error then, if in fact the defendant is derelict in bringing up an objection at an appropriate time, doesn't do it, and yet still plain error by your account would be appropriate?
Well, I would contend that plain error is not appropriate in this case. This is a case where the issue has been preserved. But I would also just say that the Court of Appeals opinion was clear about using invited error and that it was insulated from all review. And the court in the alternative said that if this were plain error, we wouldn't meet that standard. So the court was clear, the majority opinion was clear that that invited error is what the court was using. And the court pointed, again, only to the fact that at the end of the charge conference, when the court asked if there were any objections, counsel said, I believe that information that's been articulated is accurate, which I would contend is kind of indistinguishable from saying, I have no objections to, the instructions. That wasn't a discussion of a specific instruction. That was just at the close of the charge conference. Do you have anything else, counsel? Counsel said no. And the same thing after the jury instructions were read. But at that point, counsel had made the request for the instruction and received a ruling on it, thus preserving the issue for appeal.
So the distinction you then would make would be invited error is the defendant does something affirmative to produce what happened.
Yes.
Plain error would be where the defendant doesn't object, but doesn't do anything affirmative to produce what happened. And it's preserved if an objection is made before the time that the trial court allows the jury to begin its deliberation.
That's correct.
So that's the test you're asking us to adopt here?
Yes. And I believe this court, in terms of plain error and invited error, these tests have already been adopted by this court and are established in the cases. This case doesn't really raise a new issue of preservation. And let me just move on to the fact that this was preserved for full appellate review.
Well, if I could, just so I understand.
Certainly.
If counsel were to say, I have no objection to the instructions, Your Honor, would that be an affirmative action by that counsel?
No. I mean, at the
Why
charge, in the situation here, where you have the charge conference and the court at the end of the charge conference asks any further objections or requests, and counsel says no. You say, whether you say no, I don't have any objections, or no, I don't have any further requests, counsel has simply not asked for anything else. If there were discussion of a particular instruction, as in White, where the trial court says, here's the language I'm going to read. Do you object to this, or do you agree to this? And counsel says, yes, I agree to this language. I suppose you could frame it in some kind of negative. No, we have no objections to reading the language in the way that you've just read it, Your Honor. That would be counsel endorsing an instruction given by the court. But here, there wasn't even a discussion of the self-defense instruction, which is absent from the charge conference. So it would be intellectually difficult to try to transform counsel's single statement at the end of that charge conference into somehow approving affirmatively that the trial court give instructions that do not include self-defense when it just wasn't discussed. Instead, it was discussed the following morning. And this is in compliance with Rule 10 of the Rules of Appellate Procedure and General Rules of Practice 21 and the policies behind those rules. The notion in jury instructions is that we want the trial court to get it right. This court wants the trial court after, and this is different from, rulings that are made during evidence. At this point, all the evidences have been presented, and Rule 21 suggests that trial court slow down, hold a conference, and gives multiple opportunities for objections to make sure that the instructions given to the jury reflect the evidence that was presented, give the jury all of the options that they should have, and that parties can raise any requests or objections at that point. And the language of Rule 10 is about making the request outside the presence of the jury, before the jury retires. And that was completely met in this case. It was not, the request was not made at the formal charge conference, but that is not a requirement for preservation. The requirement for preservation for making it timely is really making it before the jury retires. There are even some circumstances in which, the rule is set up for corrections to instructions if it's realized that the jury needs to be recalled. And the entire point of these rules is to encourage parties to get all these requests on the record, and also to make sure that there's integrity to jury verdicts, that there's not, unnecessary questions about the instructions that are given, because this is such an important phase of the trial process. It's also,
How do we figure into it while you're there? How do we figure into it the fact that not only was there a failure of the defendant to object, but that conversely, he also agreed with the instructions that were going to be given prior to their being given to the jury?
I would just say that there's no express agreement that's relevant to the absence of a defense instruction, or even to any particular instruction that was given in this case. If there were an error in one of those instructions that the trial court had read, either if the trial court gave it differently than it was proposed, or if trial counsel had simply not made an objection, that would be, that could be raised as a plain error issue. It wouldn't be an invited error.
If one fails to object and then as well agrees with what is going to be given to the jury as a charge, then isn't the juxtaposition of the two invited error?
No. And the reason for that is if that were the case, the agreement here, this is important, but the agreement that the Court of Appeals pointed to here is simply answering the question at the end of the charge conference, do you have any objections or requests? No. That is the same as not objecting. There are these different cases like White, where there is an extended discussion of a specific jury instruction, and counsel indicates to the court approval of that instruction in some way. But that's not the case here. And none of the issue in this case doesn't relate to any of the instructions that the trial court that were listed during the charge conference.
Somewhere in the briefs, the term acquiescence is used to describe what the defendant did. Is acquiescence different from agreement?
I'm not sure if acquiescence would be different from agreement. I don't think there was acquiescence or agreement here, because the defendant made a request for a jury instruction that was denied.
So would there be a difference then if the defendant at the end of and I understand that the defendant later raised the self-defense issue prior to the time that the jury was permitted to retire and begin its deliberations, but let's just say for purposes of discussion that everything ended at the conclusion of the charge conference. If the defendant had said in response to the trial court's inquiry, yes, Your Honor, I think you got it right, that's all we need to do, would that be invited error?
No. At the end of the charge conference, again, this is no different from and not objecting to what the judge has read. There's no, the scenario you've described, there's no discussion of a particular instruction or any specific language that counsel has approved. If that's not a discussion of something very specific, to change that into a blanket adoption insulating all appellate review from anything that was read during the charge conference or anything that might have been included in the charge conference would eliminate this court's doctrine of plain error. And it would lead to attorneys having to go through this sort of formalistic second guessing of what they say at the end of the charge conference. I mean, this is a standard exchange that occurred here where the judge, in compliance with the rules, you're trying to give counsel every chance to bring something up. Do you have anything else to offer? And if an attorney should use a, phrase like, no, that sounds right, instead of, no, I don't have objections, is that really going to make is there a distinction between those two? And in this case, I don't know that it's even that clear what the attorney was going that far. It was just sort of using an awkward phrase here, right? I believe the information that's been articulated is accurate. It's an odd way to say it. And well, the instructions weren't inaccurate. I mean, the judge sort of read, pattern instructions. The question is about self-defense, and that issue simply wasn't part of the charge conference. And even if it had been, it was squarely raised the following morning.
Is your argument then essentially that if we were to affirm the Court of Appeals holding here that this was invited error, there would no longer be any plain error regarding jury instructions?
Essentially, or the only way of avoiding plain error would be being very formalistic about the language at the end of the charge conference to, make some blanket statement of preserving any issue that may arise that was not raised, or not formally, saying, well, Your Honor, I can't really agree to that, but we'll just move on. I don't know what attorneys would say there.
Before your time runs out, talk to me about why, in your view, the evidence supported a self-defense instruction here. My understanding of self-defense put in not real specific terms is that you are entitled to act in self-defense if you reasonably believe yourself to be about to sustain an injury or to have harmful or offensive contact. You are entitled to use force to defend yourself.
Yes.
The testimony that you seem to be relying on in support of your substantive argument is the testimony of Ms. Donnell, if that's the correct way to pronounce her name.
I think it's Donnell.
I'm sorry?
I think it's Ms. Donnell.
Donnell, okay. Multiple ways to pronounce it, and I can almost invariably get them wrong when we do that. But at any rate, am I correct in understanding that essentially your substantive argument is based on Ms. Donnell's testimony?
That's not entirely correct, Your Honor.
Okay, well, tell me what.
And I'm glad you brought this up. Because this is also important to the sort of side issue of discovery and a few other things. The first time that this self-defense came into this case was on the direct examination of Officer Joyce by the prosecutor during the state's case. And this is from volume 2, page 120 of the transcripts. When the state elicited from Officer Joyce Mr. Hooper's statements when he was in the hospital bed with the gunshot wound as to what happened. And that's when Mr. Hooper said that he had a conversation that turned into an argument with Ms. Thomas. She pulled out a gun and shot him in the leg. He also said that he saw the firearm and then advanced toward her and tried to get the firearm from her, and that's when they struggled.
Well, is a shooting that occurs in the course of a struggle over a gun, is that self-defense?
This is what the conflict in the evidence is here that the jury needed to resolve.
In order for the self-defense instruction to be appropriate, there has to be some view of the evidence that would permit the jury to find that the defendant acted in accordance with the legal standards for self-defense. I see evidence in the record from which one could infer that the accident, either the injuries occurred during that, the injuries that underlay the assault conviction occurred during a struggle over a gun. how does that evidence, assuming that's a fair characterization of what we've got, and if it isn't, tell me, assuming that that's what we've got, how does that support a finding of self-defense sufficient to constitute a defense to the assault charges that were lodged against the defendant in this case? I hope that's clear enough.
That's
you can
very
answer.
clear.
Okay.
The version of the evidence that I think is in the light most favorable to the defendant from this testimony and that supports self-defense is that Ms. Thomas brought the gun to the hotel room and pointed it at Mr. Hooper before the assault.
And at that point, he's entitled to do anything and everything? What's the...
Then it goes into, I mean, this is the analysis the jury never got to conduct. Who is the aggressor? Was the aggressor using deadly force? I mean, this court in cases like State versus Holloman,
for example, with
2017.
deadly force, doesn't there have to be some evidence that he actually and reasonably feared that deadly force would be used against him or that he would sustain serious bodily injury?
Certainly, and that evidence can come from inferences that the jury can make from the facts that they learn, including the presence of a firearm.
Inferences, not just any and all inferences that they could possibly make. It'd have to be a reasonable inference.
Have to be a reasonable inference, and I would point to this court's decision in State versus Holloman in 2017 about this inference issue, in which this court approved and it's very different facts there, in which we had sort of two armed parties, but there was a question about the display of a firearm. And the trial court had issued an instruction that one who initially displays a firearm to his opponent, intending to engage in a fight and use deadly force, is the aggressor and cannot sort of have the benefit of self-defense. Now, that's not quite the question here because it's not the defendant who had the firearm, but it stands for the proposition that to display a firearm, a deadly weapon, and he was ultimately shot with this, it was a loaded gun, to the other person with an intent to use it, is an invocation of deadly force that allows the person to respond.
So to understand, make sure I'm understanding your argument, is the mere display of a firearm sufficient to trigger a right to use force in self-defense?
If there's a threat to use it, and if it's being pulled out and pointed. I mean, someone points a gun at you, I think that's a classic kind of case in which you have some right of self-defense. At that point, you believe you're being threatened with a deadly weapon. And the defense evidence, the other defense evidence, aside from Ms. Donnell's statements about what, the version of the event that Ms. Thomas gave her and that Mr. Hooper gave her, was also the testimony from Ms. Machoa that Ms. Thomas had, in advance of this, said that she had bought this gun and would have no problem using it on Mr. Hooper, that there were statements from which the jury could, that would sort of bolster an inference that there was an intention to use this. And finally, there's that jury verdict on the other felony charge in this case. Mr. Hooper was facing a felony for possession of firearm by a convicted felon. The story that the state put forward, Ms. Thomas's story, was that there was a gun in the hotel room and it was lying on the stand. Right? The defense evidence put forward reasons to believe Ms. Thomas had a gun and brought it. The jury decided that Mr. Hooper was not guilty of possession of that gun, and they were instructed on constructive possession. So I think that what can be taken from that is the jury must have concluded that that was not the state of affairs, that there was not a gun waiting in the hotel room, that Ms. Thomas brought it. The jury never had the opportunity to go through the full analysis of self-defense under those facts.
Let me ask you a question that I think Justice Hudson would like me to ask. Are you asking that we adopt the dissent in its entirety, or is there any part of the dissent that you don't agree with?
This court could certainly adopt the dissent.
What would you recommend that we do? I know, the question of what we can and what we should do are frequently two different things.
Yeah, I think it would be, it would also be helpful to have an opinion from this court sort of delineating why this is not invited error and what invited error is. I believe that would be useful.
Is there anything in the dissent with which you disagree?
I don't believe so. I don't believe it.
That's always a fair answer, Mr. Crowley.
Thank you. I'll reserve my remaining time.
Counsel. From the Appellate.
Thank you, Mr. Chief Justice. May it please the court. I'm Zach Uzor from the Department of Justice here on behalf of the state. It's good to be with you all in Morganton today. The evidence at trial showed, and the jury found, that Mr. Hooper strangled and beat Ms. Thomas and did so in front of their 3-year-old son. Ms. Thomas testified under oath that in that moment, Mr. Hooper said he was going to kill her. Amazingly, she broke free and grabbed a weapon. When Mr. Hooper lunged for her, she fired a shot at the ground, hitting him in the leg. At that point, he relented and she was able to leave the hotel with her son. To the extent there was any evidence in this case related to self-defense, it was vanishingly thin. As the trial court noted, and
Of course, the standard is not whether it's vanishingly thin. The standard is whether there's any evidence of it, isn't it?
well, Justice Ervin, as you pointed out, it's whether there's evidence of each and every element of
Right.
self-defense. And as the trial court
But I mean,
noted,
the reason that things like vanishing, they worry me a little bit because that then's almost asking us to start weighing the evidence, and we try very hard not to do that.
understood. Well, let me talk about the specific deficiencies in the evidence, Your Honor. As the trial court noted, there was no evidence of Mr. Hooper's subjective belief, which of course is a necessary element of self-defense. And moreover, the state amply demonstrated that Mr. Hooper was the initial aggressor in this case, which makes him not entitled to claim self-defense. For those two reasons, the trial court did not err in failing to issue the requested instruction.
Can I ask you about the first point you made, that there was no evidence of his state of mind? And the trial court, in denying to giving the self-defense instruction, says, and because we don't know what was in the defendant's mind because he exercised his constitutional right not to testify, and we don't know what he was thinking or what he believed. Isn't that essentially creating a standard that you can only be entitled to a self-defense instruction if you testify? And
Your Honor,
that's not our law.
I completely agree. Mr. Hooper had every right not to testify. And of course, evidence of his reasonable belief can come in through other means. Our position is simply that it just didn't in this case.
Well, we haven't talked about the evidence that he offered through his mother's testimony of what the victim told her when they had the telephone conversation. And she was very clear in her testimony that she was told that the fight, which resulted in the victim's injuries, didn't occur until after the gun had been fired once.
Well, even then, and Justice Ervin, I believe, was touching on this, that is not indicative of what the defendant believed in his subjective mind was going to happen.
So you're saying it would be unreasonable for a jury to believe that if she had brought a gun, again, we have to take the evidence in the light most favorable to the defendant, that she had brought a gun to the hotel room, had fired it once, he still was not entitled to reasonably believe that he could use some kind of force to defend himself?
Well, Your Honor, this gets to my second point, which is the evidence presented that he actually was the first aggressor in this case, in which case Ms. Thomas's use of the gun would actually have been warranted. And that evidence stretches back weeks before this incident began. Evidence that Mr. Hooper routinely came to her family home, had threatened her, that she had blocked her phone number because she was afraid of him, that when they went to a family funeral, she didn't want to be alone with him, so she asked her uncle to accompany them, that he had asked her to purchase bullets for him because he was a convicted felon and could not do it himself. She invited him and her son to the hotel, and that before any of this happened, the conversation that he alluded to with Officer Joyce was him getting right in her face, asking her about romantic partners, which obviously was very tense, and then in her testimony, berating her.
Well, so I understand that the jury should weigh that evidence and should decide who they believe, and that there was evidence that he was aggressive towards her in the past. But in deciding whether or not the evidence that he presented and the evidence taken in the light most favorable to him is sufficient to support a self-defense instruction, how is all of that being evidence that's taken in the light most favorable to the defendant?
It's a good question, Your Honor. And I would point to this court's decision in State v. Coley as sort of a counterexample, because What we have here is an instance where the defendant's side of the story, if you will, is just a narrow snapshot of the course of events. In contrast to Coley, where you've got evidence that the gunshot victim had stalked and pursued Mr. Coley, who was in a wheelchair, broken his door down, assaulted him for being a snitch before a gun was fired. Here, the state actually presented a mountain of evidence that the opposite had occurred, that Mr. Hooper had actually threatened and pursued Ms. Thomas, asked her to come to the hotel room and then had started accosting her. If we take only the version of events offered to Officer Joyce, that excludes, all of that that happened beforehand. And I really don't read State v. Coley to support the idea that viewing the evidence in the light most favorable to the defendant would require us to do that.
So your testimony is, your argument is that the trial court, in determining whether to submit a self-defense instruction, which doesn't look like actually a decision to that effect was ever made here, is supposed to look at the other parts of the state's evidence in order to decide whether the evidence that's favorable to the defendant supports self-defense?
My position is that if the state has offered evidence which is in all respects uncontroverted, which I would say the evidence prior to the actual encounter at the hotel was.
Is the jury required to believe uncontroverted evidence?
No, Your Honor, but for purposes of determining whether each and every element of self-defense could be supported by the evidence, I believe it's the trial court's duty to take that holistic view of the evidence presented to ensure that all of the components of self-defense at least have some, twig to be hung on.
But you said it's uncontroverted evidence, but wasn't there also evidence that the defendant produced to show that the victim here was in fact the aggressor, that she had obtained a gun, that she had brought it to the hotel room, that she had made statements to other people before the shooting, saying if he comes around again, she wouldn't have no problem using the gun? That was also an evidence.
I think it's important to really take a close examination of the evidence here, Your Honor, because my review of the transcript, no one actually ever said that Ms. Thomas brought a gun to the hotel room. There was evidence that she had acquired a weapon for her own protection when Mr. Hooper was coming by her family home and threatening her. That was a .22 semi-automatic, completely different from the .357 that fired the shots here. So it's not inconsistent with her testimony that shots were fired. She admits that.
Was there evidence that the victim had bought a gun prior to this episode?
No, actually, I believe she acquired a gun from a friend.
Well, okay, she obtained a gun. So there is evidence that she had obtained a gun prior to this incident in the hotel room.
Yes, but
is there any evidence one way or the other as to whether the defendant knew that?
I do not believe there's evidence one way or the other as to whether the defendant knew that. Certainly others who testified at trial knew that, but as to whether Mr. Hooper knew that, I don't know. But, Your Honors, I want to just stress that the lens of viewing the evidence in the light most favorable to the defendant only applies when we're talking about whether there was an error. And even if an error occurred here, the state's position is that it was not prejudicial, because at that point, this court's review becomes objective and holistic. Would it have made a difference if the self-defense instruction were issued here?
Well, is it depending upon what standards you look at, it's either is there a reasonable possibility that the outcome might have been different, or is there a reasonable probability, depending on what standards you're looking at, right?
Absolutely, Your Honor.
So you don't have to show like a greater than, more likely than not, at least if the error is preserved.
Sure. So our position is that either standard, there was no prejudice here, but, going to whether plain error review should apply here or invited error, the Court of Appeals, I think, faithfully thought it was applying this court's precedent in State v. White.
Well, but as a practical matter, the only thing that the rule requires is that there be an objection prior to the time that the jury retires to deliberate. Isn't that right?
That's what Rule 10A2 says.
Well, that's the rule that governs whether something's preserved or not, isn't it?
I may be splitting hairs here, Your Honor,
Well,
but
split
Sure,
away
sure.
split away if need be.
sure. That is absolutely what 10A2 requires. Our position is that counsel's conduct in this case, which was vacillating and inconsistent throughout trial, obviated any objection that he made that would have in the abstract.
Well, tell me, even splitting hairs, how
Sure.
you can get that result out of what Rule 10A2 says.
Sure. So really we're getting into territory that's almost akin to waiver here. And, we were talking about some affirmative action versus, as Justice Morgan said, passivity. And if I may, Your Honor, so what we have here is an error that resulted from defense counsel's conduct. That's the second prong of the codification of the invited error standard. How did that happen? First, we have the failure to give the required notice under the statute. Then we swing in the other direction. Counsel made some insufficiency motions at the close of the evidence, which alluded to defense. That's on the other side. We've got the charge conference, at which counsel says that the instructions that were proposed were accurate. We swing back again with the request for the instruction moments before the jury goes to deliberate. And then finally, the trial court again says, now, are there any corrections that need to be made to the instructions that I've issued? And counsel says, no, Your Honor.
Well, but generally speaking, though, the rule says as long as you lodge an objection prior to the time that the jury deliberates, the instructional error is preserved. I mean, it says that, doesn't it?
I won't disagree that is what the rule says.
Okay, well, and the rule is the rule that the court has promulgated for the purpose of determining what a counsel's got to do in order to preserve an instructional issue for purposes of appellate review, right?
Well, let's imagine a scenario where...
But that's the purpose of that rule, and that's why it's there.
It is, but to push back, Your Honor, there's a purpose to the invited error rule as well, which is to preserve the integrity of the trial court proceedings and prevent counsel...
Well, all of these rules are intended to preserve the integrity of the trial process by requiring that issues be brought to the attention of the trial court so that the trial court can rule on them.
Sure. But if the issue is brought to the attention of the trial court in a way that is either muddied or inconsistent or confusing, I mean, perhaps this is not the case to articulate this point, but you can imagine a scenario where, 10 times counsel says, I don't want this instruction. I'm fine with that. And then one time they say, I think you should include it. That I think gets us closer to the line of what invited error is all about and what it's trying to do, which is to protect the trial court and not allow counsel to even inadvertently manufacture an error for appeal. So
are you saying that first, a question of what actually happened? Did counsel present its requested instruction in written form to the trial court? Do we know that?
I don't believe so, Your Honor.
So after the counsel says, well, I think instruction, whatever the number is, should be given, and when the trial court says, well, I want to hear from the state, and then the trial court rules on it, is it the state's position at that point the attorney, in order to preserve it, needs to say, I want to note an objection?
That is the state's position. And that really the pivotal moments here are the charge conference, the time immediately following, which is before the jury goes to deliberate. And then again, when the trial court, pursuant to 10A2, is trying to correct any errors and asks defense counsel if any corrections need to be made. That's really the pivotal moment here. And those are the portions of State v. White that it seems the Court of Appeals was trying to follow in earnest.
So it seems to me, having participated in these types of conferences, that often requests are made that the court may not follow, or they may follow in part. I guess the state's position would be that if a party wants to preserve it, they need to plainly say, I object that my request was not allowed.
There are Court of Appeals decisions which say that a request on its own amounts to an objection. I could not find a case from this court saying that. That seems commonsensical.
My recollection is we held something like that in the civil context in Wall versus Stout, which I think appears in volume 310, but I may be wrong about that.
Perhaps, Your Honor, I'm not sure. But
going to the Court of Appeals cases, then are you asking us to overrule State versus Roe, which is one of those instances in 2013 where the court said, as defendants specifically requested the trial court to include a jury instruction, here it was on simple assault, and argued that point before the court, we hold that he properly preserved this issue for appellate review. The fact that counsel did not say the words "I object" is not reason to deny appellate review in this case. So you're asking us to overturn that?
No, Your Honor. I am not suggesting that there's some sort of magic words that counsel needs to say in order to preserve the objection. We have not argued that in our brief, but simply that in light of everything else that happened in this trial, there needs to be some clarity about what counsel actually wants so that the trial court is not put in this position of saying, well, yesterday you agreed with me and today you disagree.
You alluded to this a second ago, and I'm afraid some of my questions pulled you off of it. So let's go back to it a second. We, of course, have a statutory requirement. I think it's contained in the discovery statutes that require defendants who intend to rely on certain affirmative defense, what would traditionally be called affirmative defenses, to give notice to the state prior to trial, so the state would be aware that they would need to deal with that offense. That was not done here. I don't think there's any question about that.
No question.
Given that the requirement is contained in the discovery statutes, is that something that should be dealt with as a discovery violation, or is there some other approach that should be taken to deal with the failure on the part of a defendant to comply with the requirement to give notice of an affirmative defense?
I think it's relevant in two ways. The first is, as you say, it could be the basis for a discovery violation, and I'm happy to talk about, why what the trial court did here was an appropriate sanction. But the second is that, as I've said, I think it can be viewed as part of the invited error analysis. Has counsel, through their actions, brought on the error that they now complain of? So this was really sort of step one, the train leaving the station, if you will, on counsel's muddying conduct that invited error here.
So let's talk about the discovery part of that a second, and we may move on to the other
Sure.
a minute later. But at least as I understand, and this is something that Justice Hudson wanted me to ask, I think, there's generally a requirement, as I understand it, that there be certain findings made in order to impose a discovery sanction. Defendant's argument seems to be, well, you can't treat this as a discovery sanction because those findings weren't made. One, is that correct, that those findings weren't made? And secondly, if so, what does the state have to say in response to your colleague's argument about the lack of findings?
I will be the first to admit that what the court said here was not the most fulsome explanation, but I do think nonetheless it satisfied the statutory requirements. Let me explain why. 15A, 910, B, and D require the court to make findings justifying a sanction. In doing so, consider the totality of the circumstances surrounding noncompliance, that's the first part, and assess the materiality of the subject matter at issue. How did the court do that? Well, it specifically noted that there was no notice given and that counsel had agreed
I'm sorry, that there was what?
That there was no notice given. I'm sorry, I'll stand closer to the microphone. That there was no notice given and that counsel had specifically agreed to the instructions the day before. That was the court's analysis of the circumstances. On materiality, The court said the evidence of self-defense was insufficient to support the instruction, in particular, the lack of evidence about Mr. Hooper's subjective belief. That was the materiality prong. So while I admit that, it would have been great if there were a more lengthy explanation of the court's analysis here, it did offer some justification. It was not just simply a summarily denied.
Shouldn't the consideration of the circumstances under this requirement include some determination of whether there was any prejudice to the state and how this impacted the overall fairness of the trial?
Well, the state is explained in the colloquy over this issue that the failure to provide notice, was a significant discovery violation because it did not allow the state to prepare to rebut the evidence that was offered. And the trial court, implicitly adopted that when it said, I have to agree with the state, who had spoken moments before the DA did. That's what I would say, Justice Earls, allows this to be viewed as a discovery sanction.
Defendant has couched what the Court of Appeals has done as an expansion of the invited error principle. Do you see it as that? Is this a straight application of what currently is that doctrine, or is it something else?
Justice Morgan, again, I think the Court of Appeals saw it as a straight application, specifically applying State v. White and the factual similarities to this case. But I will admit there are distinctions between White and this case. Specifically in White, the instruction had been requested and accepted, whereas here, if it was requested, that request was denied. But again, with those pivotal moments being a request or a failure to request the instruction at the charge conference, seemingly assenting to the proposed instructions, and then again, failing to object when the trial court comes back around and asks if any corrections need to be made. That's State v. White. We would put forward a sort of alternative theory here, which is that the amalgam of the conduct at trial could also invite error under the second prong of the codification of the invited error standard, which simply says an error resulting from counsel's conduct or defendant's conduct.
I heard you use the term assenting. There's nuance involved here. I raised the term acquiescence, which is somewhere in the materials. Is there a distinction between assenting, acquiescence, and agreeing? And all those terms have been used in some form or fashion in the appellate materials.
This is one of the difficulties of dealing with a cold record, because I think some tone would have been very helpful here. The exact language defense counsel used was, I believe the instructions are accurate, has been articulated. The next day, the trial court said, you told me that you thought they were satisfactory. So, if we could read in at all to the trial court there, characterizing the tone of defense counsel's language, I think it gets closer to assent. But you're right, Your Honor, that this is a difficult thing to assess on a cold record like this.
So what should we do with this?
Again, I would say that what this court should do is view that interaction alongside the failure to give statutory notice and the failure to later object if there were any doubt about the correctness of the instructions after the jury had been sent to retire, so that the jury could have been recalled. There's one other thing related to preservation that I really want to make sure I touch on. The pattern jury instructions that were given in this case for assault by strangulation and assault on a female actually include the phrase without justification or excuse. Without justification or excuse. The trial court delivered these instructions verbatim. This is at 238 and 239 of the transcript. I'm not suggesting that these few words are the equivalent of the pattern instruction that was requested, but to the extent there's been an insinuation in the briefing that the jury's hands were tied, that without a defense instruction, they could not have found that Mr. Hooper's conduct here was excused or justified, That simply is not the
Okay,
case.
help me a little bit. If you're not saying that that's the equivalent of a self-defense instruction, why would it then be sufficient to allow a jury to consider self-defense?
Well, I think it goes to prejudice, Your Honor, because the jury had the opportunity, they did have the opportunity to find self-defense here, even in the absence of an
Without
instruction.
instruction and without knowing what it was?
Well, again, counsel argued that, and unfortunately we don't have the closing arguments here, but counsel seems to have made it a point in this case to frame Mr. Hooper's conduct as being defensive. And I just think it's notable that the court, or the jury here rather, had the opportunity to find that the conduct was justified as being defensive, but opted not to. And that simply just goes to the prejudice prong, showing that the result would not have been different because the jury, assumedly, would have ruled the same way if given a more specified instruction.
Can I ask you your response to the argument that if we agree with the Court of Appeals analysis that this was invited error, then in every case where counsel fails to object, it's invited error, and there would no longer be any plain error review of jury instructions?
I perhaps have not made myself clear, Your Honor, because we are not arguing that agreeing with the Court of Appeals in this case would dissolve the opportunity for plain error. We're just saying under the facts of this particular case, counsel's conduct resulted in the error that they now allege on appeal.
Right, but how is this conduct different from any case? And plain error applies if there was no request for a jury instruction that was denied. So what is different about this case from the situation where there's no request for an instruction, but yet the failure to give it can, in some circumstances, be plain error?
The difference is counsel's failure to provide the required statutory notice. The language, I believe what's been articulated is accurate, which, I understand can be viewed in a number of ways. And then again, when offered the opportunity to correct any errors after having requested a specific instruction, saying no corrections are needed, that those three things actually amount to an assent.
Justice Hudson wanted me to ask you also to the last point that you made, that couldn't the comments that the defendant's trial counsel made at the conclusion of the jury charge be nothing more than an attempt to avoid doing anything inconsistent with his request that the court instruct in accordance with the patterns?
Your Honor, I think it's more likely that counsel was reweighing whether it was important to object here and simply decided it's not worth making this correction.
Is it also possible that we're going to talk about possibilities? I mean, he's already raised the question of self-defense that was shot down. I mean, what's the point in reiterating it if you've got a rule that says I asked for it once, I didn't get it? Well, already got that issue taken care of.
The point would be, Your Honor, reflecting on the confusion that there seems to have been here about whether Mr. Hooper was pursuing self-defense or not, to clarify. And to prevent, the arguments that we're having now by simply clarifying, yes, we mean to object. So I see I'm running low on my time here. Are there any further questions that I could answer either about preservation, error, or prejudice? Okay, thank you. And I'll just say again, it's an honor to be here today, and we would ask this court to affirm. Thank you.
Thank you, counsel. Rebuttal.
Thank you. I want to respond to the state's argument. I want to focus quickly on two cases from this court, State v. Maskey from 2004, which is a capital case, and State v. Dooley, a self-defense case from 1974. Maskey was a case in which an objection was made and corrections were made to the charges at issue. It was in a capital instruction context the morning after the charge conference. There'd been a charge conference. The next morning, there was discussion, and there were objections at that point. In that same case, the judge made errors during the jury instructions that were not in accord with what the parties had agreed, and counsel did not object. This court held that that was preserved and also cited its decisions from Ross and Bukulski that requests for an instruction can preserve that issue even if counsel does not notice the error during the time the instructions would be read. Similarly, the Roe case from the Court of Appeals was based on this court's case in State v. Collins, which seemed to acknowledge also that a request for an instruction is equivalent to an objection. The Dooley case I'm going to cite, and this is consistent with other cases, including Coley more recently, but Dooley was a case in which the jury was actually given the law of self-defense. And there was some closing argument on self-defense. And the case was reversed because the trial court omitted the mandate allowing the jury to use that, giving them the option of an acquittal based on self-defense. So Dooley stands for the proposition that not only is this justification language not enough, but the sense that the jury may have, in closing, heard something about self-defense, et cetera, is not enough. The jury needs a vehicle to lawfully use this evidence, and self-defense, requires them to go through this very specific analysis, which can result in an acquittal specifically on the basis of self-defense. I'm also going to note the pattern instructions do not need to be physically given in a written form. That's the point of the pattern instructions, and a number of cases, including White, involved reference to the pattern instructions, and then the parties have a discussion. It's not actually clear from the record whether the attorney handed up a physical copy or not, but everyone knew what the language was. Finally, I would also say the evidence was not entirely uncontroverted as to their relationship. This was a case with conflicting evidence about what the history they had, as well as what happened. Mr. Hooper left his hotel room 5 years ago with a gunshot wound. Ms. Thomas left bruised and scratched. The jury was deprived of an instruction that would have allowed them to use self-defense, and we'd ask this court to reverse for a new trial.
Thank you, counsel. Thank you to everyone. Again, we appreciate y'all being here in Morganton with us.
All right. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 1 p.m. God save the state and this honorable court. The Honorable, the Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon, everyone. In the late 1840s to the early 1860s, Supreme Court of North Carolina would have its August session in Morganton. In recognition of that fact, when we looked at where in the West would be a good spot for the Supreme Court to hold court, Justice Irvin, for some reason, thought Morganton might be a good spot. So we've ended up here under our state constitution. It specifies that the Supreme Court will hold court in Raleigh or such other spots as the General Assembly designates. They have designated Morganton for the West and Edenton for the East. We appreciate counsel making the effort to be here in this historic courthouse, which I hear dates back to the 1830s. You'll notice that there are only 6 of us. Justice Hudson is having to follow the protocols. And if I'd used that phrase 5 years ago, nobody would know what I meant. But sadly, today, we all know what that means. She is participating. She's watching the live stream, and from time to time, she'll be texting Justice Irvin some questions. He's not doing his social media updates. He's checking what Justice Hudson might have to say. And along those same lines, we got notice late yesterday and early this morning that the attorney in the last case tomorrow, so I've got it as case 6, but it's case 3 on Tuesday, has tested positive. And so that case has been removed from the calendar. So if y'all know anybody who plans on coming to the 3rd case tomorrow, please let them know there won't be one. I hate for them to show up and they'll be the only ones here, although this historic courthouse is so great, they'll certainly enjoy the historic tour. They just won't get the Supreme Court here. Our case for this afternoon is State versus Oglesby, and we will hear from the appellant.
May it please the court. My name is Jillian Frank with the Appellate Defender's Office. I represent the defendant, Jamal Oglesby. I'd like to reserve 5 minutes for rebuttal. Mr. Oglesby received ineffective assistance of counsel where, at the very least, his Miller resentencing court had the authority to run his murder conviction concurrent with his robbery convictions. To be sure, as all these charges were originally joined for trial by the state and they were all sentenced together, the court could have reconsidered how all of the charges were run. But at a minimum, the court had the authority to run his murder charge concurrent with his robbery conviction under either prong of 15A, 1354A. For counsel to not ask for this when Mr. Oglesby had explicitly done so in his amended MAR was deficient. The court specifically asked about its sentencing options, and counsel wrongly told the court that it could only consider how the murder and kidnapping charge were run with regard to one another. As indicated by the court's question, there was a reasonable probability that the court would have reconsidered how the murder charge was run if it knew it had the ability to do so. Therefore, Mr. Oglesby should receive a new sentencing hearing with effective assistance of counsel. I want to start out by just reminding the court of the different convictions that are at play here. In 2004, Mr. Oglesby was facing trial on 2 charges of armed robbery, murder, kidnapping, and attempted armed robbery. On the first day of trial, he pled guilty to the 2 armed robbery charges. He then proceeded to trial and was convicted of the other 3. He was sentenced for all 5 charges at the same time.
Does it matter that the events took place on 3 separate days in 3 distinct events?
No, it does not, Justice. It was all joined for trial by the state, and they were all sentenced at the same time. The sentencing court decided to run all of them consecutive to one another. So the sentences were the 2 armed robbery, then the murder charge, then the kidnapping, and finally the attempted armed robbery. The attempted armed robbery was later arrested. So now, as of right now, we just have the 2 armed robbery, the murder, and the kidnapping.
So is it the fact that they were sentenced on the same day? Or, I mean, if they had been sentenced on different days, would you concede that the court cannot go back and revisit any of that?
I would contend that under either circumstance, the court could consider at least how to run the murder charge with regard to those armed robbery charges. Since they were all sentenced at the same time under 15A, 1354A, they all constitute charges that he was sentenced for at the same time. And the court is allowed to consider how all of those charges are run with regard to one another when they're sentenced at the same time. If for some reason he had been sentenced a different day to those armed robbery charges, or if for some reason, because he did plead guilty to those charges, they could be considered a different matter, 15A 1354 would still apply, because the second clause of that statute states that the judge can consider any other undischarged term of imprisonment that the person is subject to.
And that was what I was going to ask you about, which is, at least as I read it, you've got 2 different scenarios that 15A 1345A applies to.
Mm-hmm.
One is when multiple sentences of imprisonment are imposed on a person at the same time.
Mm-hmm.
Obviously, the defendant was being resentenced for the murder.
Mm-hmm.
But the other sentences were extant already.
Right.
So is it your contention that this is a situation when multiple sentences of imprisonment are imposed at the same time?
I think you could look at it I think it would actually apply under either.
I mean, we'll get to the second one in a minute.
Sure.
But given that we're only sentencing for the murder technically right now, and when I say we're only doing it right now, I mean at the time of the resentencing hearing, how is this a situation in which multiple sentences of imprisonment are being imposed at the same time?
The resentencing hearing was nunc pro tunc back, the order that came from the resentencing hearing was nunc pro tunc back to the date of his original sentencing.
Was there any contention that you could change the minimum and maximum for any of the other sentences?
No.
So was the defendant actually being sentenced for those crimes at the time of the resentencing hearing?
I would contend not resentenced in that the sentence was being changed, but that the different terms of imprisonment that he was subject to on the same day, the court could at that point consider whether to consolidate his murder with those other charges or to keep them consecutive as they were originally.
The second prong, and you alluded to it, and I stopped you, and let's
Sure.
go there now, which deals with a term of imprisonment being imposed on a person who is already subject to an undischarged
Mm-hmm.
sentence. Now, my understanding of a discharged sentence is that that's one that's already been fully served. Is that right?
I read undischarged term of imprisonment to be any term of imprisonment that he's subject to at the time of that sentencing.
Well, I mean, for example, we have 2 apparently the Department of Adult Correction or whatever I'm supposed to call it now. I'm afraid I practiced under DOC so long I can't say anything else. Put the 2 robbery charges first.
Mm-hmm.
And at least my understanding of the record, and the ultimate question I want to ask you is, am I understanding the record correctly, was that the defendant was deemed to have been discharged from at least the first of the 2 armed robberies.
Mm-hmm.
Is that right?
Yes. At the point that the resentencing hearing occurred, according to DPS's website, he had fully served the first armed robbery charge.
But not the second.
But not the second. That one was still in play at the time.
But just to follow up on
Sure.
that, given what you said about the order being essentially going back to the date that he was originally sentenced, does this undischarged term of imprisonment apply to what was discharged at the date of the original sentencing or at the date of the resentencing hearing?
I would contend that it applies to the date of the original sentencing because this order, this judgment was nunc-pro-tunc back to the date of the original sentencing. And it specifically notes that on the judgment sheet that came from this hearing. So at Mr. Oglesby's resentencing hearing, Mr. Oglesby's attorney told the court that the only issue in front of the court at that hearing was to decide how the murder and the kidnapping charge would be run with regard to one another. So she limited the scope to just that issue. And she, in fact, told the court specifically, the armed robbery charges are not before the court. Counsel's assertion, as we were just discussing, was incorrect. Multiple sentences all imposed at the same time or undischarged terms that are pending at the time that someone is sentenced can be reconsidered on remand. So 1354 by its plain language applied to his resentencing hearing. At the very least, the murder charge, which was made consecutive to the robbery charge, would need to be reconsidered how that should run. And here we know that the court did not address that issue at all.
I'm sorry, repeat what you just said again and make sure I understood what you said.
Sure. So the murder charge, it's the default that when you're sentenced for a charge, if it is not specifically made to run consecutive by the court, it should run concurrent. At the resentencing hearing, the court did not consider whether the murder charge should be kept consecutive to that armed robbery charge that it was originally made consecutive to. It was told it could only consider the murder and the kidnapping. And I would contend that the court at that point, that actually would be an error. That's not something that's really before this court right now.
I was just getting ready to ask that, and assuming that your position was correct,
right,
is an appeal from the judgment the correct way to seek redress for the alleged error?
Well,
as compared to a habeas corpus petition or some sort of declaratory judgment.
I think that's probably another option. Candidly, that was not something that I considered when I was filing this brief, whether or not that specific error had occurred. So that's something that may still be available to Mr. Oglesby at this point. The Court of Appeals majority incorrectly concluded that 1354A had to somehow override Miller jurisprudence in order to apply in this case, and that was incorrect. The cases that it cited for this proposition didn't raise this issue and did not specifically address it. The Court of Appeals' own precedent, the de facto life without parole cases that are pending before this court, actually discussed 1354A in the context of Miller resentencing hearings and applied it. In State versus Anderson, the court noted that there's nothing in 15A, 1354A that suggests that it does not apply to a new sentencing hearing under 15A, 1340, 19B. And therefore, the court does have discretion to determine whether multiple sentences are to run concurrently, notwithstanding how they were originally sentenced. So I contend that the Court of Appeals ignored its own precedent here in failing to realize that 1354A actually did apply to the resentencing.
Well, I guess one of the things I've been asking myself as I think about this case is the issue before us a substantive error as to apparently not considering whether to, I mean, the trial court rejected an argument that the kidnapping sentence should be run concurrently with the homicide one. So are we dealing with a situation in which your argument is it was error not to consider running the robberies, one or more of the robbery sentences concurrently, ineffective assistance for failing to advocate it, or both?
Both. I raised both at the Court of Appeals. They disagreed that they could decide the issue of whether or not 1354 meant that they could be resentenced on all of the charges, or reconsolidate all the charges, which is why I also brought the IAC charge. But
Well, with respect to this, what I'm going to call the substantive charge, I hope we're on the same wavelength enough I can use that
Right.
term. Is there any, we just had a long discussion in the prior case of invited error, given the statement that your predecessor counsel made at the trial court. Is that an instance in which any substantive error that the trial court may have committed was invited?
I would contend no. I believe that
Because you've recited her as saying several times, these things are not before you.
right. I believe that counsel had a duty to present any argument that was, readily available.
I'm trying not to talk about ineffectiveness right now,
Right.
but just looking solely at your substantive claim, is there an invited error problem here?
I do not believe so.
Why not?
I believe that her limiting the scope to those two charges was simply a mistake. I don't believe that the court had any idea that it could exercise its discretion in this way, and asked her, and her response, I guess I just see that as an ineffective assistance issue and not invited error.
Okay.
Further, Mr. Oglesby's amended MAR raised this issue. So this was something that he had asked for in his amended MAR. He asked that he be resentenced to all concurrent terms. And even a diligent review of his pleadings should have tipped off his counsel that this was the relief that he was seeking. So Mr. Oglesby was prejudiced by his attorney's failure to advocate for his murder sentence to be run concurrent with the armed robbery. The court asked several times for clarification about its options, and specifically asked if there was any authority under 1340-19B, the Miller-Fix statute, that would permit the court to modify the order in which the sentence is run, as opposed to modifying the 25 to life. And his counsel's response to that was just about the kidnapping and the murder charge only.
Well, did the counsel misrepresent the law, or was the counsel just merely not utilizing a convenient opportunity that was afforded to him to educate the court?
I believe she just did not recognize this possibility. I just believe that she saw those two charges as being the ones that were in front of the court at the time, and limited her her request for relief to that issue.
Is the law clear on this matter to such an extent that the representations made by counsel were ineffective assistance of counsel because they were misrepresentations of the law?
I believe it is. I think 15A 1354A, by its plain language, applies in this case. And I believe that the Court of Appeals, at least, had recognized this fact in two of its other recent cases. So, I mean, while she didn't have those Court of Appeals cases in front of her at the time, 1354A is a generally applicable sentencing statute. And I believe that this is something that she should have been aware of. Even if she wasn't aware of that specific theory of reconsidering how the murder charge was run, in a Miller resentencing hearing, counsel's duty is to advocate for the best outcome for her client. And in this case, where her client was 16 years old at the time that he committed these crimes, her duty was to ask for the highest relief for him, and a failure to do so, I believe, was deficient.
Yeah, I'm just trying to understand. It sounds like it may be a two-pronged approach by you. Maybe it's not, but that's why I want clarification. Is your ineffective assistance of counsel claim based upon the fact that counsel misrepresented the law or did not zealously represent the client, the defendant, when given an opportunity to do so, or a combination of both?
I would say both. I think she didn't zealously represent her client by failing to ask for the relief that he asked for in his MAR. And also, I believe that her reading or believing that the resentencing hearing was limited in scope to only those 2 charges was a mistake in the law.
How can we reconcile the fact that the trial court did understand that it could sentence for the murder and the kidnapping concurrently and chose not to? How does that bear on the prejudice?
Sure. So Justice is correct that they decided to keep the kidnapping charge consecutive to the murder charge, but that was only a difference, that only would make a difference of about 2 years of imprisonment versus if the court was reconsidering or considering for the first time, this judge, whether or not the murder charge should be run consecutive or concurrent with the armed robbery charges, whether it was both armed robbery or just one, it would be a difference of 8 or 16 years. And I think that there's a very reasonable probability that the court may have looked at that and thought 2 more years, okay, that I'm not that persuaded that I need to change this for a difference of 2 years, but 16 years, maybe there's a different thought process that goes into that decision.
I mean, would it be equally likely to say that, I mean, just to play devil's advocate, if nothing else for a second, say if I'm not going to run 2 years more concurrent, I'm certainly not going to run 8.
It's possible, but Mr. Oglesby didn't have the chance to present that, so it's impossible to know.
I mean, the problem with this is you've got to, one, show deficient performance. And then secondly, even if you're able to show deficient performance, you've got to show that there's a reasonable probability, not just a reasonable possibility,
right,
but a reasonable probability that the outcome would have been different. And I'm trying to make sure I understand your argument. I've got a question or two about the first prong, but let's stick with this one for right now.
Right.
Your argument as to why there is given Justice Earls' question, why it is reasonably probable that the outcome would have been different if the advocacy had been made as you suggest it should have been.
Well, the court itself asked, it said, is there any authority under the Miller-Fick statute that I can modify the order in which the sentence is run, as opposed to modifying 25 to life? And I think that question was asking specifically this issue, is there any authority for me to modify the order in which the murder charge was run? And counsel said, essentially, we're looking at the kidnapping charge and the murder charge. So I think that shows a willingness by the court to reconsider just that, even despite what the court ended up doing with the kidnapping charge. I also think that, and I mentioned this in my brief, we've been having a continuing sea change of understanding about sentencing juveniles. And I think that if the court had been presented with this and realized that he could have went back and ran this murder charge concurrent with the armed robbery charges, given what we know now about the juvenile brain and development, they may have made a different decision.
Let's talk about the first prong a second before you
Sure.
move on. You had some discussion with Justice Morgan about why counsel may or may not have done what she did or didn't do.
Right.
Does it, in your view, matter why counsel did what she did?
No, I don't believe it does matter.
Is there any possibility that the counsel might have thought, I've got some hope maybe of getting the, and I'm now into a hypothetical, so just, Yeah, I know I'm saying something different than the record, but it said, for example, I might have some shot at getting the trial court to run the kidnapping charge concurrent, but given that it was different days, I don't think I've got much hope of persuading the trial court to run the two robbery charges or one robbery charge concurrent. Therefore, I'm going to make a strategic decision to focus on the kidnapping charge and not try to get the robbery charges. I mean, that seems to me to be at least possible.
I don't believe that any attorney who was effective would have strategically made that decision in this case. I believe that had she recognized that this was a possibility, this is absolutely an argument that she would have made. I think based on, she was zealously advocating for the murder and the kidnapping charge to be run consecutive. And like I said, that's only a difference of 2 years. I believe that if she had realized that she could possibly have had the murder charge run concurrent with the armed robbery charges, and it would be a difference of 16 years, that she absolutely would have done
So
that.
is it your contention then that there's no reason to think through what I might reasonably could get given the circumstances that I face? I've got to advocate for the most favorable alternative regardless?
I don't believe that that would be a reasonable strategy.
Okay.
I just want to quickly, I have about a minute until I get into my rebuttal time. I want to quickly just respond to one of the state's arguments from its brief that the order from the 2017 order granting his MAR was somehow limited in scope. And that order, the state actually reads limiting language into that order that does not exist. That order said that the motion for appropriate relief for a resentencing hearing is allowed. It didn't give any qualifications to that. And in any event, that was a red herring in this case, because it's clear that the murder charge, if that's being resentenced, could be considered, how that murder charge is run could be reconsidered at this point. If there aren't any other questions, I'm going to save the remainder of my time for rebuttal.
Let me jump in just for a second.
Sure.
With the amended MAR, that's the one that was granted by the trial court, right?
Yes.
It says a resentencing hearing, I'm looking at under, looks like Roman numeral 2, page 74 of the record, and it lists two of the different indictments that are numbers that are being to be resentenced and consolidated or run concurrently. Those don't include the ones that you're now contending should have been included in the mix. What do I see that was presented to the trial court to tell the trial court on notice, oh, by the way, these two armed robberies are also to be considered?
So on page 74, on Roman numeral 2, it lists two file numbers. That's 02 CRS 60369 and 60325. 60325 are the armed robbery charges. So Mr. Oglesby did actually ask for those armed robbery charges to be run concurrently in his MAR. And in his prayer for relief on the next 2 pages from there, 76, he asked for a de novo resentencing hearing and to be resentenced to one consolidated life with parole charge, and list the two file numbers that encompass all 5 charges. Its order, I think it is page 90 of the record, 92, states that defendant's motion for appropriate relief for resentencing hearing is allowed. It does not limit it. It does not say in part. It does not say resentencing as to the murder charge is allowed. So I believe that that is a red herring.
And it was the same trial judge that did both the order allowing the amended MAR and then did the resentencing.
No, it was not. So there was one judge that granted the MAR, and there was a different judge that conducted the resentencing hearing. If there are no further questions, I'm going to reserve my last 3 minutes for rebuttal. Thank you.
Thank you, counsel. We'll hear from the appellate.
May it please the court. Good afternoon, your honors. My name is Rob Ennis, and I represent the state in this matter. The sole issue before the court is whether the Court of Appeals erred by holding defendant failed to establish that he received ineffective assistance of counsel at his resentencing hearing. Under Strickland's two-part test, the defendant must show both deficient performance and prejudice.
We do have a substantive claim as well as a motion for appropriate relief of ineffective assistance claim, don't we?
Your Honor, the only issue that was disputed below on which the appeal is based from the dissent is a dispute about the ineffectiveness of counsel claim. The dissent, in its dissenting opinion, stated that it agreed with the majority on the parts of its majority opinion dealing with the structured resentencing claims.
Did it say that it agreed with the majority on its interpretation of 15A 1345A?
You're correct, Justice Ervin. It did. The dissent did not. And so, yeah, there's a disagreement between those two about the statute, section 15A 1354A. The majority has concluded, and the state would contend is correct, that a resentencing court has the authority to run sentences before it concurrently or consecutively at resentencing, but only for those judgments that are actually before the court for resentencing. And the dissent would read the statute as applying to a particular resentencing proceeding on which any person who was previously sentenced to multiple terms of imprisonment at the same time was awarded. And the statute is term of imprisonment specific, and it grants a court authority to run sentences consecutively.
How do you square that reading with the actual text of 15A-1354A? Because particularly the second and third clauses that say when a term of imprisonment is imposed on a person who's already subject. So if they're already subject, they're not being sentenced right then to an undischarged term of imprisonment, including a term of imprisonment in another jurisdiction, which again would not be someone being sentenced at that point. So how is it that this language can be read to say that it can only run concurrent when sentencing, the judge can only run it concurrent to offenses that he's currently sentencing for?
Well, Your Honor, for one thing, I would just like to point out that the dissent based its opinion on the basis that the statute applied to the defendant because he was a person on which multiple terms of imprisonment were imposed at the same time. So the dissent didn't make an opinion that the statute applied on the basis of undischarged terms of imprisonment that he may have been subject to. And I apologize, I don't think I have answered your question. But I guess reading the plain language of the statute, we know that it's directed at trial courts. It says the authority of the court. The criminal code commentary states that the section authorized consecutive sentences in judges. And the language says when multiple sentences of imprisonment are imposed on a person at the same time, or when a term of imprisonment is imposed on a person already subject to an undischarged term of imprisonment, then the court has the discretion to run sentences concurrently or consecutively.
Regardless of who argued what in the Court of Appeals, just looking at it as if we were all sitting here being trial judges together, why isn't at least the second prong of that statute applicable in a circumstance like this?
Your Honor, the state's not arguing that the statute's not applicable. The resentencing court.
Does the state concede that, again, putting aside issues of preservation, that if we have the facts we have here, that we've got 3 other sentences, 1 for kidnapping, 2 for robbery and murder, that if the murder sentence is if the murderer is subject to resentencing, that under the second prong, the trial court has the right to determine whether the sentence is run concurrently or consecutively?
Your Honor, it would be only as to what sentence the resentencing court is imposing.
Right, but
So as to the murder,
I think you're correct. I phrased that badly. Let me try again. Had the right to determine whether the homicide sentence should be made concurrent with any sentence that was not discharged as of the time of the resentencing. Does the state concede that the statute provides for that?
the state wouldn't concede explicitly, but the state
Well, I mean,
does.
how about implicitly then?
Your Honor, I guess the issue before the court is deficient performance. And so if there's even dispute about whether or not the statute applies, defendant can't satisfy her burden of establishing deficient performance unless the law is so clear and settled that no reasonably competent attorney.
And that's what I'm trying to ask is, let's stay with 1345A for a second. Given the set of facts we've got here, we've got two robbery sentences, a kidnapping sentence, none of which have been disturbed, and a homicide sentence. The resentencing on the homicide. Under the second prong of 1345A, did the trial court have the authority in the exercise of its discretion to run the homicide sentence on resentencing concurrently with the two robbery sentences?
Your Honor, under the statute, I believe the court would have had the authority to run whatever sentence it was imposing at resentencing concurrently, provided it did as it did here, which was order that the sentence be served nunc pro tunc to the date at which the sentences were imposed.
Okay.
And so, I'm sorry, getting to my deficient performance, and I kind of touched on this before, but even, if there's any dispute about whether the statute applies, the defendant can't establish deficient performance because that requires a showing that counsel's errors were so serious that it was objectively unreasonable under prevailing professional norms that no competent attorney would have taken counsel's challenged conduct. My colleague has now identified the IAC claim as being one in which the defendant or his counsel was deficient for failing to zealously represent him by not asking for the relief requested in his MAR. We know from the United States Supreme Court in Barnes that a defendant has no constitutional right to have counsel press every available colorable point requested. And we know from the United States Supreme Court in Mirzantz that counsel also has no duty to raise every available argument regardless of its merit or its viability or realistic chance of success. In this case, we have, and my colleague described the procedural history, so I won't go into that again, but we have an MAR order that only awarded the defendant resentencing on his murder conviction, his kidnapping conviction, his attempted armed robbery conviction. It did not address his armed robbery convictions. In the order, it lists only his convictions for kidnapping, attempted armed robbery, and murder that were all tried together at the same trial. Counsel also, or the MAR order also identifies the fact that his unconstitutional sentence for imposed only on murder, which was a separate judgment than the other judgments, was unconstitutional under Miller, and that he's entitled now under our sentencing statutes to be resentenced for that murder to life with parole after 25 years. And the MAR order also identified the Court of Appeals limited remand with instructions only to arrest judgment on the attempted armed robbery or the kidnapping. So defendants claim that counsel was deficient for failing to argue that the armed robbery sentences were before the court for resentencing.
But they're not. If I'm understanding their argument, and they've got a little bit of chance to tell me that I'm not understanding it, or you can tell me I'm not understanding it either, if that's correct. I understand the argument to be not that we ought to disturb, that the trial court had any authority to disturb the sentences that were imposed for the robbery. The issue is, should the trial court have considered, and did the trial court have the authority to consider, whether the resentence imposed for murder should be treated as a concurrent sentence with the robbery or not. And at least their argument seems to be that's not affecting the sentence for the robbery. That's the sentence for the murder.
Your Honor, that's correct. And that's, that's the argument now at the Court of Appeals that's being highlighted. I mean, at the Supreme Court that's being highlighted. I apologize, Justice Ervin, if you wouldn't mind repeating that question.
Sure, I'll give it a shot. I mean, you keep saying that the trial court wasn't authorized to re-sentence in the robberies. And I'm not understanding their argument to call for a re-sentence in the robbery. Their argument seems to be, if I'm understanding it correctly, that the trial court, in the course of re-sentencing for the murder, had the right to determine whether the murder sentence should be made concurrent or consecutive with the two robberies. So their argument, if I'm understanding them correctly, does not involve a change in the robbery sentence. It would involve consecutive or concurrent with respect to the murder sentence. Is that any clearer?
Yes, Your Honor. And I guess the record before the resentencing court that we know that the resentencing court was aware that the defendant had to serve 2 aggravated armed robbery sentences. In addition,
Your colleague agreed, I think said it served 1 and was in the process of serving the second.
That's
correct.
That
Right?
That's correct, at least according to the DOC profile that was included in the record on appeal. It appeared that the defendant would have been released from his second armed robbery sentence in 2021, and this resentencing hearing happened in August 2019. And so the trial court here was aware that the defendant had to serve his 2 armed robbery sentences, the minimums of those, and then the 25 years for his murder sentence, and then also the 29 months for his kidnapping. The trial court was aware that the defendant was requesting relief in the form of running his kidnapping concurrent so that he would have 29 months less before parole eligibility. And the resentencing court still decided to run the murder sentence consecutive to the second armed robbery judgment. And we know that because he checked the box in the resentencing judgment that says we're going to run this sentence consecutive to the second armed robbery judgment. So it's not a matter of the court the record not showing any affirmative action by the court. The court had to actually indicate in its judgment that it was going to run that murder sentence consecutive to the second armed robbery sentence. Had the court done nothing, that would raise an interesting question about whether if it was nunc-pro-tunct back to the date that the defendant was sentenced, then then that would run concurrently, to the date that it was sentenced. But the trial court here affirmatively decided in its judgment to run the murder sentence consecutive to the second armed robbery. And counsel, my colleague has disputed the MAR order as not granting the defendant resentencing on all of his convictions. I think Justice Morgan had mentioned, just reading the order, you can kind of tell what the MAR order was granting relief for. There's no mention of the armed robbery convictions in there. It's only mentioned of his murder sentence being unconstitutional and the Court of Appeals remand only to arrest the kidnapping or attempted armed robbery judgment.
I think this is a relevant place to insert just a question I got from Justice Hudson, who noticed, as I had, that the amendment to the motion for appropriate relief included both case numbers for the homicide and the case numbers for the 2 robberies, whereas later orders that both numbers don't appear. Does the record explain why?
You're correct, Your Honor, and the record does not explain why that is. But we can infer, based on the record that we have before us, that the court did not grant, we know that it didn't grant relief on the de novo resentencing because the MAR order doesn't discuss the armed robberies at all. It could be that MAR is still outstanding or it was ruled on in a different case, but the records doesn't tell us what happened with that request for relief in the amended MAR. But what we do know is from the resentencing judgment by Judge Wood, he made a finding in his resentencing order that the defendant's MAR and amended MAR was granted only in part. And so the defendant has stated that the state has mischaracterized the MAR order, but we have a finding from the resentencing judge in its order that says that the defendant's MAR and amended MAR was granted in part. And the defendant hasn't challenged that in the appellate court, and that's on
But
page.
If you look at the order, which appears on that page 92 of the record, the decretal paragraph number 1 says defendant's motion for appropriate relief for resentencing hearing is allowed.
That's correct, Your Honor. But we have to read the order to see what, what the order, I guess, what relief is being granted. It's just like when we are reading opinions, we don't just look at the disposition line of reverse or
That's
remanded.
generally a better practice, yes.
But we have to look at the order, and we know from the order, it doesn't discuss the armed robberies at all, and it awards a limited resentencing only for the defendant to be resentenced for the murder as statutorily required to life with parole and compliance with the Court of Appeals remand, which was only to arrest the kidnapping judgment or the attempted armed robbery judgment. And even the court's order characterized the defendant's claim in paragraph 5 as a request for his unconstitutional murder sentence to be vacated under Miller and a resentencing hearing under our juvenile sentencing statutes, which deal only with resentencing defendants who had been convicted of murder on which a mandatory life without parole sentence had been imposed. So although the court says the defendant's request for relief for resentencing hearing is allowed, reading the order shows that the order did not encompass the armed robberies. And we also have the finding from the resentencing court in its resentencing order where it explains that the judge had only granted, the MAR court had only granted the MAR in part. And again, in the resentencing order, there's no discussion of the armed robberies. So the armed robberies were not before the resentencing court at the resentencing hearing. And counsel was not deficient when she correctly told the trial court that the armed robbery sentences weren't before it. My colleague, too, has pointed out that the defendant was deficient for misstating the law. And she pointed specifically to the trial court's question as to whether there was any authority under Section 15A, 1340, 19B that allows the court to run the sentence concurrently, change the order in which the sentence is run, or change the murder sentence to life with parole. And counsel would have been incorrect to say, yes, there is authority under that statute that allows the trial court to run the murder sentence concurrently or consecutively, because there's the statute doesn't speak at all to running sentences concurrently or consecutively. And Justice Ervin, you brought up a point about, is there strategic reasons? There's plenty of strategic reasons why counsel in this position would want to focus all efforts on the kidnapping sentence and not bring the armed robberies into the resentencing court's consideration. Given all the information.
In the event that's the state's contention, wouldn't we then need an evidentiary hearing to determine whether the trial counsel actually had a strategic reason?
Your Honor, we would not, because.
I mean, hasn't this court held that whether a counsel had a strategic reason or not, in other words, did you make a strategic decision or was it just a sheer oversight, is a question of fact?
Your Honor, it's a question of fact unless the record shows that there are reasonable strategic reasons why counsel would have taken.
But to get there in this case, don't you have to hypothesize that the counsel went through the thought process that my question to your colleagues assumed? And can we do that given that we don't have any evidence as to what was the reasoning behind the trial counsel's actions?
Well, Your Honor, first I would say in State v. Garcelle, this court had denied an IAC claim that was raised by the defendant and included affidavits from counsel claiming that he was unaware that there was any basis for an objection and also claiming that he had no strategic reason for doing that. So even if counsel were to testify, there was no strategic reason for doing so, that doesn't defeat, that's not sufficient to establish deficient performance because it's an objective test. And so counsel's subjective intentions don't matter if the record shows there are reasonable strategic reasons why counsel would have taken.
So is it your contention that if the court can hypothesize a strategic reason, that's good enough to find deficient performance, even if there's no evidence that that was in fact the strategic reason that the counsel was operating on the basis of?
Well, Your Honor, the state would contend that it's the defendant's burden to overcome the presumption of reasonableness. And so the defendant has not even attempted to overcome that there be any reasonable strategic reason why counsel would want to focus all requests at discretionary sentencing leniency on the 29-month kidnapping sentence rather than the two 95-month attempted or armed robbery sentences. And there are strategic reasons why counsel would do that. One would be to keep the facts of the armed robberies from the resentencing court. The facts before the resentencing court, counsel had argued that there was mitigating circumstances because the defendant was the youngest of his co-defendants and because suggesting that he was easily susceptible to peer pressure. Bringing the facts of the armed robberies before the resentencing court would show that defendant was also with others when he committed the armed robberies, but it was he who actually perpetrated those crimes. And same gun was used to kill Scott Jester just a few days later. So that would outweigh any mitigating qualities of youth that could be argued about the defendant's young age in comparison to his co-defendants who were charged with murder. If you bring in these armed robberies, that would link him further to the murder weapon used to kill Scott Jester. Also, to bring the resentencing court, to bring the kidnapping judgment before the resentencing court in the first place, Miller only directly implicated his murder sentence. And the MAR order only awarded a limited resentencing to arrest one of the two, the kidnapping or the attempted armed robbery. But to bring the resentencing, to bring the kidnapping before the court for resentencing, it's a strategic decision to argue that the kidnapping was related to the murder because they were tried together and because it was committed during the same series of events that led to the felony murder, as opposed to the armed robberies that were not committed during the same events as the murder and were not tried at the same trial. So there's strategic reasons why the counsel would tell the trial court that the armed robberies were not before it, to distinguish the armed robberies, to try to bring the kidnapping sentence in, because there was no authority from the MAR order that would have allowed the court to modify the terms of the kidnapping sentence.
Let's go back. Justice Hudson had a question on that point. Let me ask it now. She indicates that page 86 of the record, which is where the trial court, and I realize there were several different trial judges involved in this process. I know Judge Gottlieb was involved in it and Judge Wood was, that the order requiring a response to the amended motion for appropriate relief mentioned all of the offenses that we're talking about, but that the response filed by the state did not. Do you have any understanding as to why the state's response would have not encompassed everything that the trial court's order requiring a response would have asked for?
No, Your Honor. The record doesn't disclose why that would be. It could be that the state filed the response in a different file number, but that's not included in the record. It could be that they had discussed the matter afterward and the defendant decided not to pursue those claims. We just don't know from the record. And it's the defendant's burden to show.
I mean, what we appear to know is that in the amended motion, all of these offenses were mentioned. The response order required a response to all of these offenses, and the response, however, only dealt with those offenses that were specified in the same indictment in which the homicide was charged. Is that a fair reading of the record?
That's a fair reading, Your Honor. Yes. One reason too could be the amended MAR, when it's describing the convictions, states that all of the defendant was convicted of the armed robberies. It says at trial, the defendant was convicted of the armed robberies, the kidnapping, the attempted armed robbery, and the murder. But it wasn't at trial, at the jury trial. The defendant pleaded guilty prior to the jury trial for the two armed robberies. So it could have been a misunderstanding in the amended MAR that was later identified. But again, we're just, based on the record before us, there's absolutely no indication that the trial court awarded a de novo resentencing hearing on the armed robbery convictions. But putting deficient performance aside, defendant cannot establish that he received prejudice from counsel's alleged errors. In this case, when we assess prejudice, we have to look at the totality of information before the resentencing court and whether it's reasonably probable that the resentencing court would have decided to exercise, in this case, exercise its discretion differently. And so that would require a defendant to show a reasonable probability that the resentencing court would have chosen to run his armed robbery sentences concurrently, or based on the argument today, that the resentencing court would have run the murder sentence concurrently to the first armed robbery sentence, when it had already denied his request to run the 29-month kidnapping sentence concurrently. And the totality and circumstances before the resentencing court were that the defendant was an active participant in the incidents involving Scott Jester, and he was the trigger man in Jester's murder. He and some friends decided to rob a restaurant late one night, and the only person they found was a custodian, Scott Jester. Defendant forced Jester into a car, robbed him, and then shot him in the back of the head. And also the facts before the resentencing court were defendant's significant disciplinary record. We have a disciplinary record spanning nearly the entire 15 years he was incarcerated, just up until 6 months before the resentencing hearing. And these were serious infractions just 1 year before the resentencing hearing, which included possessing weapons, being involved with gangs, participating in riots, assaulting prison staff with weapons. And this was 2 years after he filed his amended MAR requesting relief on the basis that the original sentencing court didn't have the guidance of Miller and Montgomery. Unlike Montgomery, defendant here actually had the opportunity to demonstrate maturity in the 15 years he's been incarcerated, but he's made no showing of any attempt to rehabilitate, other than the fact that he submitted a proposal to help at-risk youths a few weeks before the resentencing hearing while he was detained in Forsyth County Jail. Also, so we have those facts before the trial court. We have the nature and circumstances of the crimes with Scott Jester. We have the defendant's significant disciplinary record, and we have the fact that the trial court was well aware that the defendant would be required to serve both of his minimum aggravated armed robbery sentences and then his murder sentence minimum of 25 years, and then his kidnapping sentence of 29 months before he was parole eligible. And the trial court still found in its discretion, based on its order, that the facts of the resentencing hearing warranted consecutive sentences, and it would not reduce the defendant's parole eligibility by 29 months. Given that the same resentencing court has denied defendant's request to reduce his parole eligibility by 29 months, there's no reasonable probability that had the additional facts of the armed robberies come before the resentencing court's consideration, it would have instead granted the defendant's request to reduce his parole eligibility by 18 and a half years. So there's no way that the defendant can show prejudice in this case. We have a record that's so sufficient to show that the trial court would not have exercised its discretion in the opposite manner than it did already. So in sum, the Court of Appeals correctly held that the defendant failed to establish both prongs of his ineffectiveness claim. Defendant failed to establish deficient performance because counsel's challenged conduct of telling the court that the armed robbery sentences weren't for resentencing was correct. And even if the armed robbery sentences were before the court, or the court could run the murder sentence concurrently to the first armed robbery, defendant failed to overcome the presumption that there wouldn't have been a strategic reason why counsel would have advocated and focused all efforts for discretionary sentencing leniency as it is on the kidnapping, and not try to shoot for the moon and request concurrent sentences on all of these sentences. And second,
Can I just ask you about on this prejudice point, what do you make of the fact that the trial court did ask whether he had, what authority he had to run these sentences concurrent? If you're correct that he had no intention of thinking about a concurrent sentence, why would he ask about it?
Your Honor, I think two reasons. The first would be that the court was genuinely curious about, what the statute said and what his sentencing options would be. And also it came directly after the defendant requested for concurrent kidnapping and murder sentences. So the defendant explained that he was requesting concurrent kidnapping and murder sentences, and the court says, I'm curious, is there any authority under section 15A 1340.19b that authorizes the court to run the murder sentence concurrently rather than change it to 25 to life? So I think the question indicates only that the court was curious about its options, and then also was curious for the request of relief that was granted, if that was even possible under the statute. And the Court of Appeals also did not err under the prejudice prong, because as it reasoned, defendant cannot show a reasonable probability that the same resentencing court that denied his request for sentencing leniency by only 29 months would have granted instead a request for sentencing leniency that involved 18 and a half years. And the dissent has misconstrued the prejudice standard. It's not whether it's substantially likely a trial court would have exercised its discretion to consider an unrequested matter. That's not the standard that Strickland commands. I see I'm out of time. Thank you very much, Your Honors.
Thank you,
If there's no
counsel.
further questions.
Thank you, counsel. Rebuttal.
May it please the court, I have a couple of points that I want to make. If the resentencing court in its MAR order, or I'm sorry, if the resentencing court in its order said that the MAR order was limited in scope, the court was wrong, because that 2017 order does not limit the resentencing hearing in any way. It simply grants his MAR. This, in fact, shows that the court didn't know that it had the ability to reconsider how the murder charge was run. If the court did, in fact, include that in their order that they believed it to be a limited resentencing hearing, then that further shows that the court didn't realize that it had the discretion to do that. The state said that the dissent here found that the statute 1354A applied under the first prong, and noted that that somehow meant that this court is bound by that, and that's not the case. You're not limited by the dissent's reasoning, so this court could decide that either prong of 15A, 1354A covered the situation that was present in this case.
And I think Justice Hudson would like me to ask.
Sure.
Is there any part of the dissent's logic that you don't agree with?
No, there's not. So another contention by the state was that the court actually did consider whether or not to run the murder charge consecutive or concurrent, because it lists on its order that it's consecutive. And there's no evidence to show here that the court on resentencing considered whether it could run it concurrently or consecutively. And that's based on everything in the transcript. It was never once discussed the entire time. So I would contend there's no evidence to support that the judge actually did consider that, and it's most likely that it was just printed on the form because he believed that he had no discretion to change that. I would also contend that all the talk about this being a limited resentencing hearing that was somehow limited by the numbers printed on the form or any other explanation the state has come up with is not relevant here, because unquestionably the murder charge was before this resentencing court, and the court here could have absolutely considered whether it was consecutive or concurrent to the armed robbery charges. I see my time is up, so I'm going to quickly conclude. For these reasons and those argued in brief, Mr. Oglesby received ineffective assistance of counsel. He requests that this court reverse the decision of the Court of Appeals and remand his case for resentencing. Thank you.
Thank you, counsel. Thank you, counsel, for both sides for making the trip here to Morganton. We appreciate that. Folks here in Burke County have been so gracious. I know the court is greatly appreciative. Thank you for those of you that are sitting here with us today. And with that, Mr. Clerk.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 a.m. tomorrow morning. God save the state and its honorable court.